Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. It's good to have you all here. Let's start our day with Judge McNally.
All right. This is a drunk driving OWI. Does she stand mute and wait formal reading?
Yes, ma'am.
All right. I'm entering a not guilty plea for, is this a first offense?
Yes, Your Honor.
Allegedly, what was the,
I believe it was the IBAC. I'm going to take 2, 1. Don't walk me out. I think that was it.
she is 20, just turned 24, right?
Correct.
All right. I'm entering a not guilty plea. I'm signing your order for discovery. We'll set a pretrial date. I'm going to give you a personal bond of $1,000. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to order the man that you not purchase, possess, or consume alcohol or illegal drugs, okay? I do want you going to NA at least one time per week. You have to go in person. We're going to hand you a form. Every time you go, you have to have the form signed. And every time you come to court, you have to bring that form with you. Do you understand all that? All right. So what do you have for me, Heather?
It'll be February 18th at 9:30.
Is that good with you?
Thank you.
February 18th, you said at what time?
9:30.
9:30. Okay, that's what we'll do.
Thank you so much.
And you can, here, I'm gonna give her the form. You can just bear with me once. I'm gonna give her a copy of the, bond sheet. And, whoa. A mutilated copy of the bond sheet. Jeez. There you go, ma'am. You can approach and we'll hand you that. And,
It was a discovery order as well.
I signed that.
Thank you.
I did sign that, and you can go down the hall and they'll give you a copy of it, okay?
Thank you so much.
One other thing, you just double check something. Yeah, we're all set.
Thank you so much. Have a good day.
Have a good day. Thanks. All right. Audrey and Cousineau, 25F245225. All right. Good morning, Mr. Osmond.
Good morning, Your Honor. Jeff Osmond, on behalf of Audrey Cousineau.
Your name, ma'am?
Audrey Cousineau.
All right, so your client pled guilty to operating while visibly impaired. She was referred for a screening and assessment. Any material additions, corrections, or deletions?
No, Your Honor, and I would indicate to the court that she does have her AA sheet here. She's been attending.
Okay, and you've seen that?
Yes,
She's
sir.
been going at least once per week?
Yes, sir.
Okay. What else would you like to say?
Judge, I've spoken to her at great length about this incident. She takes it very seriously. She is going to do everything she can. She has this is totally out of character for her. No prior history with law enforcement or anything of that nature. Comes from a good family. And I'm sure we won't see her again back here.
All right, ma'am, is there anything you would like to say?
I would just like to say I'm very sorry and I fully learned my lesson from this.
Okay. All right, good enough. I don't usually only go 8 months, but she scored in category 1 on everything, so I'll go along with that. 8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no illegal drugs, no marijuana. You can't go to any place that sells or dispenses alcohol. They're recommending bi-weekly testing. I'll go along with that, but I'll only make you test bi-weekly for 3 months. If you're clean, then I'll make it monthly, okay? Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Attend a level 2 alcohol education program and the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. 4 days jail, credit 1, serve 3. I'll let you serve those by way of community service. So 3 days community service, the 6 bets, 24 hours. And I'm gonna give you until March the 25th to complete that. So you got about 7 weeks, okay? So 24 hours community service, you may be eligible for early discharge. You're gonna pay fines of 300, costs of 300, 75 victims' rights fee, $50 justice assessment, 7.25 probation fees. 160 for a total of 885. You have a screening fee of 60 for 945 plus your cost of recovery. Everything included amounts to $1,170. Again, if there are no violations, you can apply for early discharge in 4 months. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, I understand.
Judge, I'm sorry, could I ask for, she had asked me earlier, a family that she grew up with is going to Mexico from the 20th to the 26th and invited her to come with them if she could have permission to do
Yeah,
that.
you know, these states, these countries, I don't know who in, I'll just say she can leave the state. I'm not saying she can go to Mexico. You need to double check, make sure there's no problems. I'm sure there's not.
Yeah,
But like Canada, you can't go into Canada.
Canada would be an issue, you're right.
You can leave the state between February the 20. Is that-
To the 26th?
I'll make it the 27th in case the flight gets delayed. How's that? Okay. And can she pay all this today or does she need time?
I can pay all this today.
All right. I wish you well, and then you'll meet with probation, okay?
Thank you.
Best of luck to you, ma'am. Thank you.
Thank you.
Thanks, Mr. Osmond.
Yes, Your Honor.
Liliana Marie Vanderhoof, 26W8411159 A and B. Your name? Charged with driving on a suspended, you have the right to a lawyer. If you want one, I'll give you one. I can't hear you.
No.
You waive your right to a lawyer?
Yes,
On January 4 of 26, it is alleged that you did operate a motor vehicle with a suspended license on I-75 near Weston Woodhaven at 1:27 in the morning. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
yes,
Did you sign the advice of rights and read and understand the rights?
yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that? You have the right to a lawyer, as I said. Do you still wish to waive your right to a lawyer?
yes,
I'm going to enter a not guilty plea, $500 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. So those are your bond conditions. You'll owe the people of Woodhaven $500 if you violate any of those. And I'm entering a plea of denial on the speeding. You understand that?
yes.
So you're gonna go talk to the prosecutor and then you'll come back in here, okay? Thank you. Lori Hinkle.
Yes, sir.
Lori Gay Hinkle, 26W8411130 A and B. Your name?
Laura Gainville.
You smell of alcohol, I'm told, Ms. Hinkle. Are you
I
drunk?
was drinking last night.
Are you drunk?
No,
We're gonna give you a PBT, okay? You're gonna, my court officer is going to administer a PBT to you.
I
So,
was drinking until,
ma'am,
Go ahead and see the hallway.
we're gonna administer a PBT to you.
Go ahead and see the hallway.
And you'll go out and, so that goes to the prosecutor. That's the PBT. People against levity.
Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live, where apparently people are showing up to court smelling of alcohol. You gotta love it. Let's continue with Judge McNally for a bit.
This is the time and date set sentencing.
Your name, sir?
Greg Levity.
All right, I want to make sure, first of all, have you had a chance to review, he pled, by the way, to this, under height at a window peeping,
That's correct.
and, he was to go to AANA twice a week. Have you
Yeah.
seen that form?
10 visits.
He's been doing that? Okay,
Yeah.
good.
Should I submit this to your clerk for copy?
No, that's all right. I trust you. He's gonna need to keep that, okay?
Well, he's been doing really well on that.
Good.
Very seriously. Whenever you're ready, I can address the PSI.
Yeah, have you had a chance to review the report? Now,
We did, we looked it over this morning. I went over with my client. The only The only real issue is that we had, seems to me like outpatient counseling is a bit extreme. If he's testing twice a week, he's been clean, he's been following the court's recommendation and order. As far as AA goes, maybe if the court was inclined to entertain that particular element, that if he tested positive, maybe that it could trigger outpatient. Because he expressed to me this
I
morning.
mean, I think their concern is, you know, he had THC in his system. He acknowledged he was using marijuana and he had 10 beers and now he's going in the backyard of somebody's house and window peeping. I mean, I don't think it's that extreme, but I get it. Go ahead. I'm sorry. I didn't mean to interrupt.
No, and I think that's a very valid point, and I think that's something that he expressed to me this morning was that, you know, I think he's relieved that this ended where it did, you know, and it didn't result in something more extreme. You know, I mean, people get shot for stuff like that. And that was something that he expressed to me was that, you know, in the grand scheme of things, the severity of it was probably as minimal as it could be. But Judge, yes, I would say that, you know, given the fact that you know, going to 2 AA sessions per week and has, you know, weekly or bi-weekly testing, whatever the court would order on that. If he did test positive and he's quit smoking marijuana for the most part, I think. If he tested positive for alcohol or drugs, any illegal drugs at any point in time, then at that point in time, couldn't that trigger an outpatient program?
That's your argument.
Yes.
I got it. Anything else? Either one of you?
Reed, you have anything?
I just want to say that was a dumb mistake, and I'm glad it turned out the way it did. Could have been a lot worse.
And you went over and got fingerprinted, right?
Yeah, I did. Right after the last court date.
By the way, I just need to ask, is there a Tyler or Brooklyn Wilson here?
Drop this off.
All right, I'm going to take this under the Pharmaceutical Training Act as agreed upon. That's what you guys agreed upon. I'll do that. 15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're just kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing PBTs bi-weekly for 4 months. If you're clean, I'll then make it monthly. No contact with Brooklyn Wilson or her family members. No contact with her or her family members. You're not to enter the property or go near the property address of 19116 Hyde Park Court in the city of Woodhaven. I'm going to order 4 days jail. I'm going to let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that for a total of $105. And 1 day or 8 hours of community service, which you have to complete in this case by March the 20th. I am going to order that you continue attending AANA twice a week in person until you're in outpatient treatment. I'm going to order outpatient treatment as well. You're to attend that and complete that. Fines. So you understand the sentence so far?
Yes.
Fines are 100, costs are 200, 75 victims' right fee, $50 justice assessment, 4 1/4, screening fee 60 for 485. Probation fees are $300 for $785 plus your court work program fees. Your total's $890. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford them. You understand that?
Yes.
All right, that's what I'm gonna do. Does he have all of this to pay?
I'm sure he probably would need some time to make payments, Bill.
How much do you have today?
I didn't want to pay it all time sheet.
I didn't ask you that. How much do you have to pay?
I can pay 100. I can pay 100.
$100 now, 75 a week. You can do that, right?
Yeah.
75 per week. I'll give you a little bit of leeway or give you a little bit of a head start, so to speak. So I won't have you pay this until February 7th, and you'll meet with probation. And if you ever don't have the money, you call the clerk and on Zoom, I'll give you an extension, okay? Honor before the duty. Good luck. Thanks, counsel. Lori gave.
Good morning once again, everybody. TCF Live. Good to have you here. Lots of courts just getting their days started. But I'm going to hang with McNally for a little bit because I want to see if the person comes back that they did the PBT for.
You're drunk.
Ah, well, there you go.
Well, sir. I got stuff.
You said no, sir. What's your name? Tell me your name.
My name's Lori Gainville.
You got a .166 on the PBT.
I was drinking until 4:01 and I didn't. Hell, that I couldn't believe that was.
You're still drunk.
No, it was.
Both, no.
Man, we got a .166. Who drove here?
My friend.
Who's- Is this the guy here? Did he drive?
Sir Ronald Raymond Middleton, the left president.
Slow down.
President.
What?
of the United States.
Hang on a second. Who?
The 11th president to the United States president.
What's his name?
Sir Ronald Raymond Hamilton. The president to the president.
You ready?
Yeah.
The President of the United States?
Yes,
The president right now?
yes, sir.
He's shaking his head no. Why is he shaking his head no? If he's not the president, why?
No, he's not president. He's the 11th president.
11th cousin. He's shaking his head no. That he's not the 11th cousin. And honestly, I don't care if he's the brother of the president. It's not going to help you, so I don't need to hear this. What I do want you to know, if you show up for court again drunk, we're going to have a big problem. I'm going to reschedule your case. Sir, you cannot let her drive. Do you understand?
Thank you, Church.
Well, you know, you got to.
Pledge allegiance.
I'm sorry?
Pledge allegiance.
Pledge allegiance? Is that what you said?
Yes. I'm unjustified.
Just relax. Heather, give me another date, will you please? I should probably have you locked up until you go down. Give me another date.
We could do February 18th at 9:45.
Come on up here, sir. What is your name?
My name is Ron and
Did you drive her here?
yes, I did. I smelled the alcohol when she got up.
You live with her?
She stayed with me last night. She asked me 2 days ago if I'd come with her. I told her yeah. She left my house when she got
Is she gonna have access to a motor vehicle?
no. Not that bad.
Do you own a motor vehicle, ma'am?
That's what
Does she?
a 2010 Ford Focus,
She owns it.
light gray.
Well, hang on a second. You just told me she didn't have access. If she owns a motor vehicle, how does she not have access to the vehicle?
I'm a woman. Not just. I picked him last night.
Go down the hall, get your new date. It's going to be February 18th
February 18th.
at 9:45 in the morning.
You think 45 an hour, no alcohol.
Don't show up drunk. Don't show up after consuming alcohol.
Okay, sir.
We understand?
Okay.
Sir, I'm gonna let her go. I'm gonna trust you're not gonna give her those keys.
Thank you. I'm trying to get her into a treatment center for alcoholism.
All right, let's not have any further discussions here, okay?
Okay.
That's what I'm gonna do. Do not drive. Do you understand?
Yes,
Do not drive. You understand?
Yes,
Sir,
Go down the hall. They'll give you a notice. Thank you.
What an amazing way to start our day here at TCF. This is why you join us every morning. You never know what you're going to get. What struck me, though, is this whole, like, 11th cousin twice removed of the president or whatever. Why in the name of all that is good would you even try to throw that out there? Because this country is completely polarized, and you don't know what this judge's political affiliations are. You're either going to have him like 100% on your side or 100% ready to put you up against the wall. I mean, that's like the worst thing you could do is bring anything like that into the court. I'm so confused. It's good to have you all here. Let's continue with McNally for just a little bit longer.
Of operating while visibly impaired with the OWI to be dismissed, true?
That is accurate.
Is that what you want to do, Mr. Hamill?
Yes, Your Honor.
If you do that, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right at a trial to testify or remain silent with the understanding that if you choose to remain silent, that silence would not be held against you. You have the right to cross-examine the prosecution's witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. And if you plead guilty, you'll be giving up all those rights, and we will not have a trial of any kind. Do you understand that?
Yes.
All right. You understand when you plead guilty here today that you're giving up the rights, you're waiving the presumption of innocence, and you're waiving the requirement that they prove you guilty beyond a reasonable doubt. You understand that?
Yes.
All right. To the charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle in the city of Woodhaven, County of Wayne on January 4th of 26 on Allen near Van Horn at 2:59 in the morning?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, and about 6 beers.
Okay, was your ability to operate that motor vehicle impaired because of the alcohol consumption? And if so, in what way?
Yes.
How?
Drunk.
I know, but why were you pulled over by the police? Were you
Oh, I
weaving,
was,
swerving, speed?
Sorry, sir. I was sleeping. Well, the train pulled up and I put my car in park and I fell asleep.
I see. You think you did that at least in part because of your alcohol consumption?
Yes.
And did you take a breath test or a blood draw?
I did breath.
And counsel, were the results 0.136 and you so stipulate that that was an accurate reading for purposes of the plea?
There were actually 2 BACs. And yes, I stepped, Your Honor.
Are you on probation or parole, sir?
No.
Anybody forced you to plead guilty?
No.
Plea is accepted to that charge operating while impaired. The OWI is dismissed. He is 32, right? All right.
I'm 32.
I'm going to give you a personal bond of $1,000. I'm going to order a screening and assessment. John,
Yeah.
go over to probation, see if they can screen and assess him today, will you? You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I do want you going to AA 1 time per week.
Your Honor, what's the first name?
Hamill. we want to check and see if they're going to be able to screen them. They're really busy over there right now. Or do they want me to set a date? Okay, I want you to call over to probation. 734-671-0201. That's 671-0201. Extension 245, and see when they want him to come in. They're really busy. They're not gonna be able to do it right now. So, and I'll give you a new sentence date or a sentence date, and we'll go from there.
Thank
What do
you.
you have for me, Heather?
To February 18th at 8:30.
At 8:30, council, okay?
Yeah, do you need us by Zoom or in person on that day?
I mean, if he's gonna be in the only, I want sobriety court cases by Zoom, I mean, in person. Other than that, if they're, if he's in your office with you, I don't have a problem with Zoom, okay?
No worries.
Either way, so you both show up here or you both show up there.
Thank you,
February 18th, 8:30. Anything else?
Nothing, Your Honor. I will call probation and try to get a schedule.
Thank you. Have a good day.
All right, for those of you who have just recently joined, and the rest of you, good morning. It's nice to have you here at TCF Live. Tonight, 7 p.m. Eastern, 4 Pacific, as Barbara just so kindly put in the chat for us, In the Blind with Mike and Dan. Mike, the official TCF weatherman, panelist on Sidebar, and guest host when I'm not available, joins me for a show where we have no idea what we're going to talk about until we go live and it's presented to us. It's a lot of fun. Do please join us there tonight. Again, there's a link in the chat for that. And if you're not already subbed to that channel, please go over there and sub. It's a new place for us, and we need all the support we can get so we get found. Let's change it up a little bit. Otsego County, Michigan, Judge Mertz, where justice is best served in a converted pole barn.
Should also make a $300 deposit for his funds costs.
Okay, what would you like to say, counsel?
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
There is not, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Just, this is a first felony situation, so there's a recommendation of probation of 18 months. And in regards to any jail time, they're suggesting that any additional jail time be held in advance. I would just ask the court consideration of that. The court should also consider the fact that half a gram of meth is involved, in which case we don't believe with that kind of quantity, all jail time should be held in advance. Thank you, Judge.
Thank you, Mr. Trush.
So, Your Honor, I would agree with the prosecutor. I mean, this is, to an extent, I agree with him that it's first felony situation. The only prior offense that exists on his record is a misdemeanor for not having insurance. The circumstances here, he comes to the attention of law enforcement because they can't read his license plate. And he has a bench warrant because he hadn't appeared in court for the other matter. He thought it was a traffic ticket that he could just pay. So again, he had a warrant out for him for that. I think all of those things are relevant considerations. He doesn't have any history to suggest that this is a pattern. I think probation is a good idea because again, while there's no history to suggest it's a pattern, that would suggest that we're on the front end of what could be a problem in the future, which is the exact situation I think appropriate for probation. The amount here again is relatively small. He comes to the attention of law enforcement and again, a fairly benign way. There's just nothing here to suggest any aggravating factors. That's why there's no scoring for any OVs. It's why the guidelines are 0 to 3 months. At that range is a presumption against jailing. So I think the recommendation here for probation is entirely appropriate. If the court did hold some jail in advance, I don't necessarily think that's inappropriate. But I also don't think it puts the court in a substantially different position than just imposing a straight probationary term. There's obviously the added step of an actual violation hearing versus just imposing, but really I think that a probation term
is the appropriate response here. Mr. LaRock has already been in touch with Mr. Bernickel since the PSI has been done to make arrangements to have it transferred to his home county in Saginaw. So again, I think that all indications are probation is appropriate and he will be successful in probation.
Thank you. Mr. LaRock, anything you wanted to say today?
I'll ace the probation thing. Sure. I know if you allow that, I appreciate it.
Okay. All right. Well, I did read through the report, so I'm familiar with what happened in this circumstance. There's also a lot of information in that report about you, Mr. LaRock, your circumstances, your background and history and so forth. So I take all of that into consideration along with what the lawyers have had to say here. And yeah, you know, I tend to agree with Mr. Trush. There aren't any real aggravating circumstances here, other than you had an unresolved warrant out of Oscoda County. But, you know, in terms of this traffic stop, it doesn't appear from the report that you were, you know, resisting or giving the police trouble. The amount that you were found with is a relatively low amount. It's a personal use amount. It doesn't indicate any circumstances involving trafficking or selling methamphetamine. And you don't have any prior history other than that Oscoda, you know, insurance issue. You don't have any other prior history. So this is one of those cases we're dealing with a non-assaultive offense where the court finds the presumption against jail time applies and is appropriate in this case. There aren't any real factors that would the court could articulate that would require or allow the court to impose jail time on this charge. Up front, I am going to hold jail time in abeyance. Yeah. And so that means that if you successfully complete your probation, you would never need to serve that jail time. But if you don't, if you violate your probation, the court can impose any or all of that jail time up front immediately, no hearings, nothing, you just go right to jail. So that's a significant motivation for you to comply with the conditions of your probation, I hope. Otherwise, I think probation is appropriate. I think some monitoring. I don't know, you know, why you had methamphetamine, if it's something that you're using regularly and this just happened to be the time you got caught with it, or whether this was a one-time use. But either way, the fact that that you've got possession of substances that you don't have a prescription for should be a wake-up call to you that you either need to go to a doctor, get a prescription, use those things legally, or not have them, because otherwise you're going to wind up in trouble like you are now. So I think the recommendation is appropriate. The court is going to follow that. The court is going to place you on probation for a period of 1 year. The court is going to adopt as the conditions of the probation all the terms and conditions listed in this report. Your agent's going to go through all of those with you individually. It's important that you know and understand all the conditions of your probation so that you don't violate them. The court is going to impose 3 months in the Otsego County Jail. You do have credit for 5 days served. The court is going to hold that time in abeyance to be used at the discretion of the court. The court will order a crime victims assessment of $130 or costs of $325, attorney fees of $350, $60 DNA testing fee, $68 state cost, and $30 per month supervision while you're on probation. You do have the ability to seek an appeal of this sentence. And Mr. Trush, have you been able to provide Mr. LaRock with his appellate rights?
I'll go over them with him right now.
Ms. Davis, is he going to meet with you?
Yeah,
today?
I was just gonna have it.
Okay. To reflect, Mr. Rock has acknowledged receipt of his, Rock has acknowledged receipt of his appellate rights.
This is just for your records. We're all set. Danielle, on your way out.
Lucky going forward, Mr. Rock. Although,
Okay, friends, let's stay in Michigan, but we will head southeast, Lenawee County. Say good morning to Judge Anzalone.
Michigan versus Daniel Mark Knobloch, file number 25-22389FH. I have John Glazier appearing on behalf of Mr. Knobloch. I have Isaac Sneed appearing on behalf of the people. This is date and time set for a pretrial conference in this matter. Mr. Glazier, how would you like to proceed?
Your Honor, I believe my client, I think they've offered him a DV deferred, and I think he wants to avail himself of that. I just wanted to make sure that that would not involve initial upfront jail, and on deferreds it usually doesn't.
Okay, so Mr. Sneed, I do see that count 2 is domestic violence. I do see that the prior plea offer was plead to domestic violence first offense under 769.4A, which I believe is the misdemeanor deferred statute. So is that a correct recitation of plea, and what is your position on upfront jail?
That is a correct recitation of the plea, and we don't have any position on upfront jail.
So, all right, so Mr. Glazier, if they have no position, then I would have no objection, no upfront jail as a cops.
Okay, then we're set to go.
All right. Do you want to do this? All right, so Mr. Knobloch, my bailiff's going to hand down to you an advice of rights form. I'm going to go through those rights with you, but if you could read through it real quick, go ahead and read through it and then sign it when you're done reading through it.
Judge, it might be easier for me to establish the basis.
Sure. Okay. He's reading through his advice rights, and then I'll go through them with him.
Okay, what a sign right here.
Well, he's reading what is apparently the longest document ever created by man. Reminder that we are on Discord, and if you are a channel member especially, this is useful to you, because in the 4th hour here, you're allowed to join me to talk about and share your thoughts about anything that we saw during the day or anything else going on in the legal world. But the link every day is posted over in the Discord, so you want to be signed up for that if you're a channel member. If you're not a channel member, you still want to be signed up for it, because Discord also gives you alerts every time we post and go live, and you can't count on YouTube to do that for you anymore, unfortunately. I'm sure Barbara will drop a link here in a moment for the Discord, but if you're not signed up, go do that. Very helpful.
Them on the record with you as well, okay? So raise your right hand, Mr. Knoblaw. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and can you put your hand down, and I just need you to speak up a little bit louder. So you are Daniel Mark Knoblaw.
Yes.
All right, so Mr. Knoblaw, you have heard the statement of your attorney and the prosecutor and myself. Is it your intention today to plead guilty to count 2 domestic violence 1st degree, which carries a maximum penalty of up to 93 days in jail and a $500 fine with a Cobb's to no upfront jail because people had no position? And then that would be under the deferred statute. So if you successfully complete probation, it won't stay on your permanent record. Do you understand that?
Do I have to plead guilty or no contest?
Mr. Glazier, what are we doing?
It might be easier as a no contest, Your Honor.
Mr. Sneed, any position?
No, thank you.
Okay, so your attorney is asking you to plead no contest. So is it your intention to plead no contest to that?
Yes.
Okay,
Yes.
and you understand count 1 will be dismissed, which is the assault with intent. Do you understand that?
Yes.
Okay. Now, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes.
All right, and neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
Mr. Sneed?
Yes, Your Honor.
And Mr. Knoblaw, to your knowledge, is that correct?
Yes.
All right, so if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? So by pleading, you have to apply to the Court of Appeals in the Supreme Court for an appeal. You don't get an automatic right like you would at trial. Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court would not be bound by any sentencing agreement or evaluation, and you would not have a right to withdraw your plea. Misconduct is defined to include, but not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, sir, about the rights that I've given to you?
No.
Okay, so your response to my next question will be no contest or not guilty, okay? So how do you wish to plead to the charge that on or about June 18 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence? No contest or not guilty?
No
Do you want to
contest.
sit down? Would you like to sit down? I'm sorry. It's okay. There's a tissue box there and you have a seat. Miss Adams, could you call for Claude Howard from the jail, please? Okay, so take a deep breath. You're gonna be okay. And when you're ready, we'll proceed, okay?
Good.
Okay.
Okay.
Okay, tell me when you're ready. Okay.
Can I help you with anything?
I don't know.
If you need a minute, I'm fine with that. Do you want a minute, just a minute, or are you ready to continue?
I'm ready.
Okay, so your attorney said that you're gonna plead no contest.
Okay.
So my question is, how do you want to plead to the charge that on or about June 18 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence? So no contest or not guilty?
That's no contest.
Okay, okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
Yes or no?
He's
Not really.
not really? Okay, so we talked about what your sentence would be in the deferred, but he hasn't promised you what you'll have to pay in fines and costs or anything like that.
He told me what it might be,
Okay,
what it might be.
okay, okay. But you understand I set the sentence, right?
Huh?
You understand that I determine what the sentence is, correct?
Yes.
Okay, all right. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats? Wait, I think I already did that. Did I already did that? No, I didn't. Do you understand if I accept the plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or it was not your own choice to enter the plea? So this is your choice to enter the plea, right?
Yes.
Okay, and you're doing this of your own free will, right?
Yes.
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
And is it your own choice to plead guilty? Or no contest, I mean?
Yes.
Okay, so, Mr. Glazier, you said you wanted to place a factual basis on the record?
Yeah, it might be easier. Mr. Noblock, you've come in to talk to me about this at least 2 or 3 times in my office. Is that right?
Yes.
And
Think so.
the last time we were in here, I told you they had offered you a misdemeanor deferred with no upfront jail, and you wanted to take that deal rather than go to trial. Is that correct?
Yes. Yes.
And we actually had an exam on this, and you heard what's her name? Amanda Wilson testify at that trial under oath, or at the exam under oath. Is that correct?
I never heard her, no.
Were you at the preliminary exam? Do you have a hearing downstairs where they took testimony? Okay, do you remember being, all right, so I have paperwork shows that you held a preliminary exam, your attorney questioned witnesses, and so did the prosecutor way back in the summer in August of 25. Do you remember going to court in August and the judge hearing testimony and you sitting with Mr. Glazier? Mr. Glazier, I think that if you and Mr. Sneed stipulate to the, for
That's
purposes
fine.
of a no contest plea, Mr. Sneed, would you stipulate to him using the preliminary exam transcript and the police reports?
Yes, thank you, Your Honor.
All right, so, Mr.
Your Honor, we would just stipulate that at the exam, that the victim, and again, I forget her name, Amanda Wilson did testify that there was an argument. My client was moving out. They had been in a relationship and he was going to leave, and that she says that there was a physical altercation, that he choked her. I just want to put on record, my client denies that, but for purposes of taking this plea on a no contest, we would ask the court to accept that testimony.
And based on the statements by Mr. Knoblaw, I would say it'd be for lack of memory, Mr. Glazier.
That and lack of memory, as well as the potential for civil liability.
All right, Mr. Sneed, anything to add?
I would just add, she further testified that 2 days later that the defendant had grabbed her aggressively on her upper right arm, and that led to 2 small bruises being observed on the victim's arm based upon him grabbing and pinching her arm.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on June 18 of 2025, in the city of Adrian and the county of Lenawee, that the defendant did commit the offense of domestic violence by choking and then grabbing the arm of the victim, in this case, Amanda Wilson, leaving bruises, which satisfies the requirements. The court does find that the defendant did commit the offense of domestic violence and accepts the no contest plea. Ms. Adams, I'll need a notice of hearing from Mr. Knoblaw for sentencing on March 20. All right, at 8:15. So I accept Mr. Sneed, has court complied with MCR 6.302 B, C, and D?
Yes, thank you, Your Honor.
Mr. Glazier?
Yes, Your Honor.
As I said, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's to no upfront jail based on the people having no position, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Ms. Adams, could you write on that notice from Mr. Knoblaw that he needs to report to district court probation on February 12 between 8 and 10 a.m. on the first floor?
Yes.
Okay, so I'm going to refer this matter to Mr. Knoblaw. I'm going to refer this matter to the district court probation department for a pre-sentence investigation, okay? Because it's a misdemeanor, the district court probation department will do that pre-sentence report, okay?
Okay.
When you go there, February 12th, next Thursday, a week from tomorrow, it'll be on the first floor of probation between 8 and 10. You're gonna go there and they're gonna set up a time, or they'll meet with you that day. Be truthful with them about your background, but you don't have to say anything about this offense because you pled no contest, okay? They'll prepare a pre-sentence report. We'll provide it to Mr. Glazier. I think he mails them out to you, but if you need to talk to him, make sure you call him in advance of that, okay? And then I'm gonna set sentencing on March 20 at 8:15 in the morning. So Mr. Knoblaw, do you wanna come in person or do you wanna Zoom in?
Mr. Knoblow, maybe you want to do it here at my office. If you want to come here at the
Okay.
office, we'll Zoom and do it right here from the office. Would that be good?
Yes, yes.
Okay, so on that March 20, you go see John Glazier at 8 o'clock in the morning and you'll Zoom from his office for sentencing, okay?
Okay,
So my staff is gonna bring you, stay right there, they're gonna bring you a notice of hearing for sentencing, and then on it will be instructions for you to report to the probation department, all right?
okay.
All right, so we are all set. And I have the advice of rights on them already, Mr. Glazier, so that's good. And you just stay right there, and when my assistant brings you the notice, you can leave then, okay?
Okay.
All right, thank you.
Morning once again, everybody. It is TCF Live on a Wednesday. Good to have you all here. Great Granny, thank you for subbing over at In the Blind. There's a link for that up in the pinned chat. And we hope we can see you over there tonight, 7 p.m. Eastern, 4 p.m. Pacific. Mike and I have no idea what we're going to talk about until we are live. That's what makes the show fun. We shoot from the hip. We learn some stuff. We have the format of the show is we have 2 different topics. We give 20 minutes each to each topic, and then we have a true-false lightning round, which is all sorts of crazy, so be sure to check it out. Time to head south. Wade Mercer, first appearances.
Ms. Knuckles, good morning. Ms. Knuckles, you're here because you've got 2 allegations against you, ma'am. You've been accused of 1 count of grand theft in a new charge, and then you have a second charge of violation of state probation, ma'am. I'm going to go ahead and address your bond status on the grand theft first. Let me see if the attorneys have any additional information. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So, Ms. Knuckles, you're entitled to a bond on the grand theft. I'm going to set your bond at $10,000 cash or surety with the condition of no contact with the alleged victim. Ms. Knuckles, the problem is that you have a no bond violation of probation warrant signed by the circuit judge, Judge Garcia. So even though you've got a bond in the new case, there's no point in trying to make it because you've got no bond in the VOP. In the VOP case, I'm going to go ahead and arraign you because I want to get you a lawyer appointed today if that's what you're asking for. In the violation of probation charge, would you like to have an attorney appointed to represent you?
Yes, sir.
Did you say yes?
Yes. Yes.
Okay. I'm going to appoint the public defender's office to represent you in the VOP case. Listen to Mr. McDaniel, and we'll see if you have any questions in just a moment.
Your Honor, we're going to enter plea of not guilty as said on the March 3rd court docket, and attorney will talk to her on that day.
And Mr. Mitchell, anything from the state?
No, Your Honor.
So, Ms. Knuckles, an attorney will see you on or before the court date, ma'am, in March. And you've got no bond in the VOP case. Do you have any questions, Ms. Knuckles?
I have no clue what this is about. I feel like I have been totally,
Okay.
I just got shocked.
The allegation is that you sold a piece of property and don't respond to this. I'm just telling you what you're accused of. The allegation is you sold a piece of property and there was some kind of pump on the property on some kind of spring, and that the paperwork clearly says that went with the property. And then weeks later, after the sale, allegedly, you removed that pump valued at several $100s. That's what you're accused of. That's the basis for the grand theft, and there's supposedly some witnesses that saw this. So that's what it's about. Don't comment on it. I'm just trying to make sure you know what you're accused of. Do you have any questions?
All right, we'll go to you now.
We have Tina Taylor next.
No, you do Richard Smith next.
Sure, Richard Smith.
Taylor.
Mr. Smith, good morning. Mr. Smith, you're here because you have a holdout of Calhoun County. Mr. Smith, I took a look at the warrant this morning. It has no bond on it. It's several felony charges down there. Mr. Smith, what that means is you're going to be held for Calhoun County. You'll get picked up by them the next day or two. When you get down there, you'll go to another first appearance, Mr. Smith, and that judge will address whether or not you're entitled to a bond. But right now, there's no bond on the warrant. Mr. Smith, do you have any questions?
Oh.
Know what he's trying to say to you, Wilson.
Hey, Mr. Marshall, I got a year county probation for all them charges. I bonded out of here and went to Calhoun and signed a year county probation for all them charges. They got dropped down to a misdemeanor. I never caught a new charge. All I caught was a failure to appear here in Jackson County. And I signed 5 years probation in CREMO yesterday. I'm just trying to figure out what this is going on, like what's up with this. 'Cause I never caught a new charge.
Let me go look at the warrant because these are recent warrants. Let me see when these supposedly happened. I looked in the warrant system this morning because it's not in their regular system. It's only in our warrant system.
Your Honor, I will tell you that he did enter a plea yesterday. So what he's saying about entering into probation with CREMO is true. I don't know if this was already pending charges that he had simultaneously.
Yeah,
This warrant was signed yesterday at 11:09 a.m. supposedly regarding an incident on December 15th. December
December
15th.
15th, I was in jail.
So there's a ag assault on December 15th. The second charge is ag assault. The third charge is false imprisonment. And then there's a battery, all allegedly occurring on December 15th. So
I was in
what I
jail
can
on
do,
December 15th.
it's not our county. Well, that doesn't mean you, I don't know anything about it. It could have been something that supposedly happened at the jail. I have no idea. I'm going to ask Mr. McDaniel to notify his counterpart in Calhoun County, Miss Parrish. And if there's an issue, this is something you've already resolved. Obviously, they're going to be on it this morning. Okay.
Yes, sir. Appreciate you.
Yes, sir. Have a good day. After Mr.
Tim, thank you for gifting 5 memberships. Very much appreciate that. All of you in the community, very much appreciate all of you. Thanks so much.
Come on up, Mr. Stanford. Corporal, this is similar to a federal warrant or an immigration only hold when there's no local charges. I don't have any authority or jurisdiction over him at all. I can't first appear him. Mr. Stanford, you have a hold, something to do with the U.S. Navy, some kind of being AWOL allegation, but it's not something you have anything in state court on. Mr. Stanford, do you have any questions?
No, sir.
All right. Wish you the best, sir. So, Corporal, it'd be just like a U.S. Marshal's hold with no local charges. There's no point in putting him on the first appearance docket.
Yes, sir. We figured, but we weren't 100% sure.
No problem. I've never seen one of those before, so thank you.
Yes, sir. No problem.
We had Fiona Best, Mr. McDaniel.
No. Tina, I'm sorry. Oh, Fiona Best is, she is out of the, she's at the hospital, Your Honor. She's,
Okay.
yeah.
So Ms. Best has a medical situation, and she's got a violation of state probation with no bond and a hold out of Bay County. So, Corporal, just keep us up to date on her situation when y'all know more, please.
Yes, sir.
Appreciate it.
I'm gonna go ahead and enter a plea for, I talked to her, so I enter a plea of not guilty and ask to settle on the March 5th for now, Your Honor. And, we'll go from there, see what happens with the hospital stay.
Okay.
She
So that'll be
was
Judge.
unconscious when she left, so I don't know what's gonna.
If they admit her at the hospital, Corporal, considering that you got 2 counties involved, so probably the thing to do is y'all to contact Judge Garcia. If there's a request for a medical furlough, but Judge Garcia is going to have to communicate, knowing her, she would do the same thing I would do. She'd communicate with the Bay County authorities before granting that. But she don't do anything until we see what happens with the intake stage at the hospital.
Yes, sir.
All right, and that brings us to Tina Taylor. Ms. Taylor, good morning. Ms. Taylor, you're here, ma'am, for a sentencing in Jackson County case 25-556 CT. Ms. Taylor, you entered a plea to the charge of driving while licensed, suspended or revoked. Your sentencing was set for yesterday at 8:45. Judge Garcia was covering first appearance yesterday, and my understanding is she did first appearances and you still weren't here. She issued a warrant, and then at some point, a little while after that, you showed up downstairs with 2 small children, is what I was told, for a sentencing, which is inappropriate. But you were taken into custody and you're back this morning. So, Mr. McDaniel, I know that I haven't heard anything since this morning, and I don't know if Mr. Mitchell has. Have you had a chance to look at any of her documentation that she was supposed to bring with her to court yesterday, Mr. McDaniel?
So I don't know anything about this case. I'm not a court tour, but she does have her schedule here when she clocked in and out of her work. And I'm not sure what y'all want to know about it, but she does have that with her.
All right. So Ms. Bess, I'm sorry, Ms. Taylor, do you want me, Mr. McDaniel, to represent you for sentencing purposes this morning?
Yes, sir.
Okay. So Mr. McDaniel, I want to make sure if you're involved, we do it appropriately and get you your fee if you're entitled to one. I think you are. So Mr. McDaniel, the question, I sent you a text this morning. The question, she was supposed to show up at sentencing with proof that she is getting off work on November the.
This is for 3 months, and that was at 10 a.m. to 2:30.
November the 9th, she got a ticket at approximately 2:40 a.m. She said she was just getting off work. I set a sentencing date because Mr. Mitchell was asking for a jail sentence, but the state and the court wanted to know if that was true or not.
That was
November the 9th at 2:30 a.m.
So we need to go back. I don't see the date on there, but he did it.
Yes, December. What day was that on? A weekday?
November the 9th. You're asking what day of the week?
Yeah, let me look at it and see. This is gonna be here. See, November 9th, would have been a
Sunday.
Sunday.
Nothing. Sunday, Sunday. Monday. No, that's not it. This I just saw it. Can I see? Five to 2:30 a.m. I got off at 2:31.
So she looks like she got off work at 2:30 or is clocked out at 2:31 a.m.
On November 9th.
Yes.
So, Miss Taylor, the other question I had is, why would you bring two children with you to a sentencing yesterday, knowing that you know
They
there
were
was a possibility of you
leaving.
going to jail?
They were leaving, Your Honor. They was dropping me off. They was
I
going
don't
with my
understand.
niece.
Why
That
did they
was
come to the
my
office
ride.
with you? Why did they come into the office with you then?
The bailiff told him to. He told us all to come.
Okay,
They was
ma'am, so tell me what happened. You showed up here yesterday morning after school time started. Why wasn't the older child in school?
my oldest child. She is she got her GED. That was my niece. And then my 7-year-old, I was taking her. She said her stomach was hurting, so I was gonna take her, have her go with her cousin to the doctor. And my 4-year-old isn't in daycare anymore, so they were together.
So you get here and you come into the probation office or the judge's office, the courthouse,
No,
right?
I went upstairs, sir, first. I went to upstairs and
Right.
then I went to the courtroom. I didn't see anyone in there. And then I saw the bailiff and he asked me where I needed to be and what it was for. And I told him my name and he told me that they had already called me. And then that's when he told me to sit down and then he went and spoke to Miss Garcia. And then he told me to hold on. And then he came out and then we went downstairs together with the bailiff. So he told us, he said, are they with you? I said, yes.
Back to my question then, why would the children come in court with you if they were just dropping you off?
Because she wanted to make sure I was there. I wanted to make sure like they'll be okay. I wanted to give her my phone. And then once I got in court, they were gonna leave.
Okay. So Mr. Mitchell, I watched the video again to make sure I remembered everything. At that point, the state was asking for 30 days in jail. She had a recent, as in maybe July, driving license suspended or revoked in another county. So I thought the offer was very reasonable, but after hearing her version and her employment history and her taking care of her children and so forth, there was some concern the state had and the judge had, frankly, about not necessarily wanting her to lose her job. So we came up with this solution to see if she really was leaving work like she claimed she was. And apparently she was, based on what Mr. McDaniel was seeing this morning. So has any of this changed your recommendation, Mr. Mitchell?
Based on the information that's been provided to both the state and the court, our recommended disposition would be changing it to 1129 probation with a $400 fine, standard conditions that follow this type of charge.
Okay, thank you. Mr. McDaniel, anything else on behalf of Ms. Taylor?
No, Your Honor.
Ms. Taylor, I think Mr. Mitchell's reasoning is well sounded. It seems like he's being logical. He's trying to help you, and I appreciate that. I'm going to go with his recommended disposition instead of doing the 30 days in jail that they were originally asking for. Having gotten more information, I'm going to sentence you to 11 months and 29 days probation. You'll have the standard conditions of probation, plus you'll have the standard court costs and fines of $400. Ms. Taylor, you will also have the standard condition that you obtain a valid driver's license if one is reasonably available to you, and that you not drive without a license. So here's what's going to happen, ma'am. Ms. Taylor, the jail's going to let you use the phone to contact anybody you wish for transportation, and then they'll let you get dressed in your regular clothes. They'll bring you to the courthouse. The probation office is at the courthouse. That's why they'll bring you here. When you get here, you'll meet with the probation officer, Mr. Goodson or Mr. Ham will go over the probation with you. They'll answer any questions you have. They'll give you a copy of the rules in writing, and then you'll be free to leave. Ms. Taylor, if you call friends or family, you can tell them you can be picked up at the courthouse in probably 30 to 45 minutes. Ms. Taylor, do you have any questions?
No, sir. Yes, I do.
Okay.
Since it is so hard for me to get my license, is there any way I could apply for like a hardship Cause I looked into it and it says I would have to have a court order.
There's no such thing as me. I don't have there's no judge that can order DHS&B to give you a court order. That's impossible. What can happen is Mr. Goodson can take a look at your driving record, and he's a probation officer. He's kind of our resident expert on driver's license. He's very knowledgeable in that area. But he could probably take a look at your driving record and tell you whether or not you may qualify for a work permit and what you would have to do. You'll be expected to get a driver's license if one is reasonably available to you. So some people got to pay a ticket and get a license, and that's all there is to it. Some people, it's much more complicated than that. And if you can't get one, you can't. But you'll be expected to at least look into it and make an effort. So Mr. Goodson will be the one to ask that question, okay?
Yes,
Your
sir.
Honor.
I just heard her
if we
say
want-
about I'll let her know. I heard her say about a high cost. I mean, usually if it's because of fines and things like that, they will work out the clerk's offices in the state will work out payment plans. And that way you can get your license as long as you continue to make those payments as you agreed to with them, then you'll keep your license if it's financial.
I think there were 5 unpaid tickets from Washington County. When I looked, when she pled, that's what was on the video. Mr. Mitchell.
I guess, I don't know if it makes a difference, but I guess for purposes of the record and maybe to help her out, we can put on the disposition letter that the state has no objection to a work permit or a hardship license. It may help her, it may not, but can't hurt.
And the state's input on the civil matter I don't think it carries.
Yeah.
It's like my input. She's got to comply with DHS&B. They're their own
entity.
rulemaking. She's either got to pay the tickets or enroll in a payment plan, like Mr. McDaniel said, and then she may qualify, I think. In Jackson County or another county. So our clerk, Ms. Williams, says you've got a criminal court costs and fines in Washington County that's going to be paid too. Something that was driving to suspend a license over there.
I think that's what.
So you'll get to use the phone in just a few minutes, ma'am, okay?
Okay.
Thank you. Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
And Corporal, anything else from the jail?
No, Your Honor.
Alrighty, friends, good morning once again. Happy Wednesday to all of you. Let's head back up to the cold north. Judge Mom.
Works for American Airlines. He's been stranded in Charlotte. He called last night, and I asked if he could call in to confirm. I haven't heard back, but he has been trying to get back. Apparently, they were snowed in over the weekend, and that's his home base. And
His home base is Charlotte?
Yes, he leaves here and works there every week. Well, I guess you got to start somewhere, and they send him south. So, they fly when there's seats available, and he couldn't get a flight back yesterday, and he was trying to get back this morning. I believe he'll be home tomorrow. If you'd like me to bring him in just to have steps that I'm not making this up.
Okay, so let's do this. We already adjourned it once. However, that was not based on his schedule. That was based upon council's schedule. So I will indicate that defendant not present. So we will adjourn to February 5th, which is tomorrow. He's home today?
No, he's coming home today, so I'll bring him in tomorrow.
Right, he's coming home today. Okay, for arraignment only.
Thank you, Your Honor. And I spoke with the clerk, and we can handle it next week. We've written out a plea on this, so I'll bring him back next week for a plea, if that works with the court. We're not gonna overburden the total time on this. We'll get rid of it. Conflict.
Okay, I'll see you both back tomorrow. Oh, I'm sorry, at what time, Gally? Oh, probably 8:30.
Probably.
Okay, we'll see you back tomorrow morning.
Thank you, Judge.
On that one.
I may have another one here.
Yes, I think you do.
By the way, Your Honor, can we go back on the case?
Okay.
I just want to let the court know that I understand that he may have had some contact with your children in coaching, and we waive any, Ms. Morito.
Okay, yes, I was going to address that tomorrow.
Okay, I don't see any conflict there. I mean, this is just a simple misdemeanor charge, but I don't see a problem, so.
Okay.
Thank you, Your Honor.
Okay.
If you want to do my other one, I'll wait. I don't see-
Well, because Mr. DuBois is not in here right now.
I have Smeagol.
I thought you have Jennifer Jackson.
No.
Whose phone is that? All phones are to be off? You don't have Jennifer Jackson?
I have Jackson, she just got out of the hospital with a stroke, and I got a notice that said it was next week. I told her don't hurry in. So Michelle said you would put over till next week.
Okay, so let me just move that. And then who's the other one you have?
The appearance present we were meeting is Smeagol, Smiegel.
Oh, James?
Yes, Your Honor.
Okay.
Okay, so do you have your appearance now?
Yes.
There's no talking in court. Please remove your hat. Excuse me, sir, excuse me. Your hat comes off. You're in court. Thank you. And there's no talking in court. If you want to have a conversation, you can continue to have that conversation in the lobby. Okay, so, counsel, if you can just make sure you're getting that appearance back in the file. All right, so let's go on the record in the matter of the city of Wyandotte versus James Smeagol, 251665.
Edward Zelenak, on behalf of the defendant, Mr. Smeagol, give your full name, speak clearly and audibly.
James Walter Smeagol.
All right, thank you. And thank you for dressing appropriately for court. Today is the date scheduled for the arraignment and pretrial in this matter. And counsel, ask the arraignment.
Your Honor, we'll waive the reading, ask the court to stand and you enter a plea of not guilty, and we're prepared to proceed once you do that, as you set bond conditions.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then as to the pretrial, counsel.
Your Honor, they've made a generous offer for the added con operative mobility, visibility impaired due to the consumption of alcohol, stipulate the blood alcohol results of 0.224. And it is driving, we ask court to accept the plea, then they're going to now cross the original charge and the PMT accused. There's a blood analysis in the file that shows blood level, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
You also understand, I'm sorry, knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
Counsel, if you can please bug your client.
All right, sir, on the date in question.
November 5th.
November 5th of 2025, you're operating a motor vehicle in the city limits of City One. Is that correct?
Correct.
Prior to operating that vehicle, you would consume the alcoholic beverages, and you would estimate 10 would be like a good start, is that correct?
Yes.
They were alcoholic beverages, and you were drinking at a licensed liquor establishment, and then you drove home. Is that correct?
Correct.
Your driving attract the attention of the Wyandotte police officer, to which you went over lane markers, you stopped at a passenger crossing path, and then accelerated what appeared to be a high rate of speed. Is that correct?
Correct.
And then you were given a blood test at the hospital, which the results, I believe, are on 224, and you have no reason to contest that result. Is that clear?
No.
You're not, in other words, yes, you're not contesting it.
No, I'm not contesting right now.
It's more than enough, Judge.
All right, and then you also failed to maintain your lane as well, correct?
Yes, Your Honor.
The court satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea, the two original charges per the plea agreement. And then as to sentencing, counsel.
Judge, you pick a date as to the bond, Mr.
I'm sorry, as to bond.
Yes. I won't agree with the sentence. I've had a abrupt start here. Two people not showing. Now, Mr. Smeagol is a school teacher in another school district. We'd asked for a reasonable personal bond. He's been here, he's presented himself since this happened, and I don't think he's lived in the city all of his life. He'll have any problems with him reappearing.
All right, and sir, where do you teach?
In Dearborn.
Okay, and how long have you been there?
2 years.
And if you were to test right now, what's in your system?
Nothing.
You had any medications?
Like for blood pressure and stuff like that.
Okay, and have you ever failed to appear in court for any reason?
No.
Are you currently out on bond?
No.
Any other jurisdiction?
No.
Any probation or parole?
No.
Sir, it's a very high level that's involved in this matter. The court wants to.
Luckily, man, Your Honor, he's very lucky today.
Yes, the court wants to ensure the safety of the public in this matter as well. So the court's going to order the following bond conditions. You're not to possess or consume any alcohol or drugs unless prescribed, and you are to participate in random testing. And the court's going to order a $7,500 personal bond.
Thank you, Your Honor.
So you're going to go over to probation, sir. You're going to get a copy of your bond conditions. You'll get a link for your needs assessment, as well as paperwork for your pre-sentence interview. Then you will also receive your dates for your pre-sentence interview, and then your sentencing date, which counsel you can coordinate with your calendar as well.
Thank you, Your Honor.
Thank you. Have a good day.
We'll see you tomorrow morning. Thank you.
Okay, thanks, John.
All right, we will keep an eye on Judge DeSanto's court, probably come back later, but let's head to Texas. Time to see John Stevens.
Busy doing something.
He's working hard on, Your Honor, I
Yeah.
agree.
It's hard to say that without laughing. No, there she goes. You couldn't say it without laughing. Is it? You're Mr. Kohler?
Yes, sir.
And you are charged here in 25, a CR 722 with a third-degree felony of illegal possession of a firearm by a convicted felon, which carries with it, you probably appreciate, carries with it up to 10 years in prison if convicted. Do you understand?
Yes, sir.
All right. Are you still at 109th Street?
Baldwin, Louisiana.
Okay, yeah.
Yes, Your Honor. Mr. Gowton, we're still working through discovery. We're asking for one brief reset.
4 weeks, okay.
Yes, Your Honor.
And other than that case out of Harris County, that conviction out of Harris County, does he have anything else that you know of?
No, Your Honor, I don't have this.
See, I'm surprised that that was a felony. Actually.
No, sir, that's the only, see on.
Okay.
And he has a GPS monitor. I think he ordered it last time. He does appear, he has it on and he just,
All right, get a resetting for. Okay, thank you. Yes, ma'am. Ross Owens. That's you?
Yes, sir.
And 25 CR 533 here, you, sir, are charged with second-degree felony of burglary of a habitation, carrying with up to a couple of years in prison. And what are we doing today?
Yes, Your Honor. Mr. Gowton, we're still working through discovery as to on this one as well. I believe it's Kenesha's case and he wants time to talk to her as well.
That's strict violations of these rules. You can only have one resetting during an announcement document. Or didn't we make that rule last time, James?
It only applies to Miss Bailey.
Yeah, that's what I thought.
She has some time to be.
That's what I thought. It's not real old. And I'm like, granted, is 4 weeks going to be good?
Yes,
for
sir.
everyone? And sir, are you still at 445?
Yes,
Okay. Well, please get a resetting.
Yes,
Thank
sir.
you.
Thank you.
Pamela, first, good morning. Good to have you here. I don't know if we've seen you here before or not, but I'm guessing not because you're saying we're going to different courtrooms. That is what we do here at TCF Live. We move around the country. We check out different courtrooms, different perspectives, different cases. We don't just settle on one thing here. So sit back and enjoy.
Marsh here. That's you. And what about Sheena Miller?
She's here.
Is she in the custody?
No, she's in the back. She's legally dead.
That's her?
Yeah.
Okay, y'all can be seated. Hold on. Darren Porter.
He's here. You're not.
He needs to talk to me personally about it. Come on, Mr. Porter. Because I told him, I've already had a long talk about the way this goes. And he's come right out of the box and is not following what we talked about. Okay, let's see. In 25 CR 335, sir, you or Darren Porter with Mr. Just a second. Yeah, he needs to, while I'm thinking about that, I need to talk to him. personally, because we had some chats and commitments, and they're not being followed. On Mr. Macon, on Mr. Porter. No, okay, this is this is a difficult one here. You're talking about habitual felon on this one? He's charged with a second-degree felony of burglary of a habitation. In paragraph 1, he's been convicted, it states, in 89 in the old days, burglary of a building, which was a felony back then. And then thereafter, it alleges that after that was final, he committed the felony of sexual assault of a child, a second-degree felony, and was also convicted next door in 2005. And then now this happens. So if all of this is true, you're looking at a minimum of 25 years in prison, minimum to life imprisonment. You understand? Yeah, that's easy to understand. I mean, it's numbers, and you get punished not only for the crime but for criminal history. So criminal history can enhance the punishment range, and it does in this case. And that's why I always tell people, don't commit crimes. And I'd be out of a job, and I think I'd like it. It'd be a better world. That's what I want, a good world. I see in the file, the state has filed a motion to increase bond.
That's correct, Judge.
It was filed January 22nd.
That's what today is set for, yeah.
What is his bond?
You don't have that over 30,000.
Real quickly.
Michael, thank you for gifting a membership. Very much appreciate that. Joining us from the dentist office this morning, I assume?
Okay. Let's see where we are here.
We're prepared to go forward with a hearing, Your Honor, on these allegations.
What does that mean? I mean, a trial?
He's not, well, it's going to be a trial on the case in chief, but Mr. Ham has made some allegations that he's threatening or trying to interfere with a witness, and we're prepared to go forward on this.
All right. Go ahead. What do you want to present?
Yeah, my witness is outside the courtroom. I'd like to call her if you want to. I'm just checking to see if you want to do it from the table or from here or from the tables.
This is fine.
Step call Mary Griffin.
This bond, I don't believe was set by me. I think it was set by Justice of the Peace in this.
Yes, sir.
And what's right off the bat on the Four Corners is the grand jury indicted you for burglary of a habitation, but you have a burglary of a building conviction in 1989. Burglaries are burglaries are burglaries. That concerns me.
He received a 5-year sentence for that, Judge.
I wonder why that didn't make an impact. I'm speaking rhetorically, why that wouldn't have made an impact. It's like touching a stove. You get burnt, you got 5 years imprisonment, right, for the burglary? Didn't you?
Yes, sir.
Okay. There you are for another burglary. Now, you're presumed innocent, but that can affect the bond because it's a similar type crime.
Griffin?
Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Thank you. Go ahead. State.
Can you state your name for the record?
Mary Griffin?
And do you know a man by the name of Darren Dwayne Porter?
Yes, sir.
Do you see him here in the courtroom today? Can you point to him and identify something that he's wearing? And may the record reflect she's identified the defendant, Darren.
Yes, it will.
And how do you know Mr. Porter?
I was engaged to him. We lived together for 6 years.
So time is going to be relevant here.
I was going to ask you, I bet I stepped on what you got. When were you married to him? What period?
Not married, engaged.
Okay. What period of time was that?
From 2019 to February of 2025.
Okay. Thank you.
All right. So, and that's where I was headed. The engagement ended a month after this particular charge. Are you familiar with the charge that he received of an offensive burglary of habitation that was supposed to have occurred on January 5th, 2025?
Yes, sir.
And has Mr. Porter had conversations with you about that date?
Yes, sir.
What were the nature of those conversations?
Mr. Porter informed me of his arrest, and I had already moved out at this time. And he asked me if I would be willing to write a letter for him stating what he wanted me to say, and he offered to pay me $100 to do it.
All right, so put it in common nomenclature. He was asking you to be his alibi witness?
Yeah.
Were you all
For a fee, yes, sir.
for a fee? And we actually talked about the amount of money that he offered you. Can you tell the judge what that was?
$100.
So not really much in the big picture of things, but he was seeking your testimony, asking you to basically be a paid witness for him as an alibi.
Yes, sir.
How did you react to that?
Well, then I wasn't gonna perjure myself for him.
And at that time was.
Did he ask you to perjure yourself?
Yeah.
Okay. Maybe I'm stepping on you. Go ahead.
All right. So specifically, he was asking you to say what, ma'am?
He was asking me to specifically state things that were in the back of his truck, according to what he said were in the back of his truck when he left the house that morning, that were not there.
All right. So he was asking you to remember back to January 5th and state certain things about it.
Yes.
And the things he asked you were untrue.
Yeah.
And that's where your problem was, right?
Yeah.
At that time, was he represented by a different lawyer?
Yes, sir.
Did you advise them that there was a problem in that regard?
Yeah.
Who was that?
That was
Right.
Brian Lane, wasn't it?
Yeah.
And you actually know his assistant
Lynette, yes.
and you talked with her about that, right?
Yes, I did face to face and over the phone.
Specifically, did she advise you to just be truthful about whatever testimony there is?
She advised me to do not say anything that was gonna get me into trouble.
All right. So did you write the letter he asked you to?
I did not, he did not, I wrote a letter from what I know.
Yes, ma'am.
When he got it, he crumbled it up, cussed me, shot me the finger, and told me it was not what he needed for me to say. So, then I'm not gonna say anything else, I'm not gonna lie.
So whenever you found out that we had this case here, did you actually contact me in regards to some of the things that were taking place?
Yes,
Did you volunteer to come in and give a statement?
yes,
And did you do that, in fact, via video?
yes.
Other
Have
than
you had a chance to see that statement?
it's a part of the discovery, Judge.
Okay. I just was gonna make sure Mr. Macon has an opportunity to see them. Anyway, delicious, thank you.
And in addition to that, did you provide text messages that you received from him about his attempts? I call it influencing your testimony, but obviously we're covering a lot of things here.
Yes, sir.
And have you told him you didn't want to be involved?
Yes,
Does he continue to try to contact you in that regard?
yes.
Hold on, help me out on dates or times.
I'm going to get specifics if I could, Judge. In fact, I advised you at some point in time that I let his lawyer know what was going on and I filed this motion to increase. Do you remember that? I told you for your safety, I'd let the lawyer know, kind of be aware that he may be contacting you.
Yes, sir.
What date was that?
January 26th.
How much did he
Yeah.
Okay.
How much has he tried to contact you since that date?
That was the date he
Yes,
tried
ma'am.
to contact me.
Yes, ma'am.
I don't know. I showed you the text messages, 8 or 9, and a missed phone call that same day because I didn't answer.
So all on the same day that we let the lawyer know and we filed the motion, he contacted you with 8 to 9 different texts and attempted to call you.
Yeah.
Are you aware that I advised his lawyer that the contact needed to stop?
No, sir, I was not aware.
I didn't tell you that in our phone conversation?
No, you didn't tell me that.
Okay. May I approach, Jeff?
Yes.
I'm going to show you collectively what I'm going to mark as State's Exhibit 1. Ask you to look at that. Are these the text messages that you provided to our office?
Yes, sir.
Go ahead and look through them.
So this is quite interesting what we've stumbled in here too, just to bring you up to speed in
Yeah,
case you
that's
joined
all in one
recently.
Right, so
This guy
since,
in front of judge for other charges. They're bringing up the fact that it looks like he tried to buy a witness.
Or mark this as State's Exhibit 1. These are the ones with the darker colored format.
That's Facebook Messenger messages.
Thank you. That's what I was going to ask you. How did you receive these? By what method?
Facebook Messenger.
All right. So if we look at State's Exhibit 2, that's one with a lighter background. What texting message was this?
Regular phone texting.
All right. So this would have been on your cell phone. This was, which is States 2. States 1 is via a social media texting. How can you be certain that it's Darren Porter that sent you these things?
Oh, that's his name and number, so.
Had he contacted you via these means prior to
Yeah.
this case?
For 6 years, yes.
So when we look at State's Exhibit 1, does it identify an individual by the name of Dwayne Porter as sending those messages?
Yes, that's his middle name is Dwayne.
And is that how you know him via the picture on Facebook and Facebook Messenger?
Yes, that's our dog.
Are the dates? And actually on these, I see a time of 6:02. Do you know what date that was received?
Oh, that's from my phone, the time that I sent it to Mr. Turner.
Okay.
I mean, I could go back and look at the dates that were on it. Most of that.
Last page
That
indicates.
August 4th. Yeah, most of these were during the summertime. That's right before his first court date he had. He was trying to get me to do the letter.
So can we assume that these are August 4th of 2025?
August 4th and before.
Okay. Let's switch over to State's Exhibit 2. This is identified as DP, Darren.
There.
Is that how you identified him in your cell phone?
Yes, sir.
These are notated with dates that appear to be August 4th and some times. Is that of 2025?
Yes, sir. Yeah, he went back and forth between the two. Was messaging, alternating.
Here you tell your State's Exhibits 1 or 2.
We have no objection.
They are admitted.
All right, so let's start with states one, the Facebook Messenger. What's the gist of what the judge is supposed to be getting here out of this conversation there?
Basically, it's him asking me, am I going to help him? Let's get down to business.
What is the help in the business?
Him wanting me to write him that letter. And then he's telling me in there that he's gonna compensate me for it.
All right, so that's the gist of States Exhibit 1. States Exhibit 2, around August 4th, where at some point in time, did you have him blocked and then unblocked him?
No, he had blocked me and then he unblocked me. And then he was asking me, was I at lunch yet? I told him not yet, but I was gonna be there shortly. And he said, okay. And then he kept on about asking me about, was I gonna help him? Are you gonna help me? Just tell me if you're gonna help me. I told you I would compensate you, all of that.
In fact, in this message, there's a reference about the offer I made him before, is there not? Is that a yes?
Yes, there is.
It's clearly talking about the situation and what he's dealing with, right?
Yes, sir. It's clearly talking about how, it was 25 to life and then 15 years and yeah. Clearly talking about it.
This paragraph here, which begins with basically, is he talking about the facts of the case and the allegations here?
Yes, he is. And that's what he wanted me to put in the letter too.
All right, so he wanted you to say, basically, because basically, again, it's nothing but point of a finger. Like I said in the first report, nothing is said about a house. The second report, all of a sudden, there's a window raised and I pulled the cord out that's conflicting stories on 2 separate days. You just can't keep adding, especially on the first report. You have 5 more lines you could have used. I'm going to take a picture of both of them. I think it gets cut off there and show you tonight.
Yes.
What's he referencing there?
He is referencing the victim's testimony.
That's right.
His written statement to the police. He said that it changed multiple times. There was one version in the beginning, and then it changed to an extension cord being taken out of a window. And that's what he was saying, that there was 5 additional lines originally on the first statement that the man could have put that, and he didn't, that he changed his story and added more stuff. And so that's what he was telling me about.
All right.
So I'm a little fuzzy here. Are you talking about the complainant? Is she referring to the?
Yes.
Yeah.
The complainant
in the burger of a habitation.
Yes.
And I'm a little fuzzy about this. What is the connection of the defendant to this building, this home?
That's unknown, Judge.
There's no connection.
What's the connection of the defendant to the complainant?
None.
Oh.
He didn't know the complainant and he does not know the house.
Oh, this just chosen at random?
Yes, sir.
There are other facts involved.
Okay.
All right. So
I didn't know if that was her home before
No.
or they were living in or something. That was fuzzy.
So these messages, and specifically that last little bit we were talking about, is him trying to get you to write that letter,
Yeah.
and which you've not done.
No.
And now that we brought it to the court's attention, what text did he send you on January 26th? Like, pull out your phone and read them.
Are you asking for State's Exhibit 2 to be placed in that?
I asked for both States 1 and 2, and I believe there was no objections, Judge.
And they're admitted. If I did it already.
First he tried to contact me via phone at around 2:35, January 26th PM, and I did not answer. He sent me a message on Facebook Messenger at 2:36 PM and just said my name, Mary. At 3:12, I messaged back and said, do not contact me again as I was instructed by the DA's office. He messaged me again and said, what do I do with your mail? Now, I haven't lived with him over a year and he's just now asking me where to send my mail.
Didn't he specifically ask for your address?
No, he didn't.
Okay.
He just asked what to do with my mail.
Okay.
And I simply replied 3 letters, RTS, return to sender. That's all I said.
And that's the only reply you gave on January 26th of
Yes,
2026.
that's correct.
Have you repeatedly asked him to stop contacting you?
This was the last time I asked him to do not contact me. I have not replied to any of the other messages that came after that.
Have I covered to the extent of what he's talked with you about, ma'am?
Yeah.
All right. I'll pass the witness.
Go ahead, Mr. Mason.
Ms. Griffin, you had a 6-year relationship with Mr. Porter,
Yes.
and it ended, and he subsequently got married to another woman, correct?
No, that's not how it ended.
Did he get married to another woman?
I don't have any idea what his personal life is.
Okay. Didn't you and Mr. Porter have a bunch of controversy over $10,000 that was missing?
No.
Didn't he loan you $9,000 for your son?
No.
Yep, okay. Well, she's denying that, but
Yeah.
I'm curious what that has to do with the subject matter how's that related to this hearing anyway? I'm lost on that one, but she's denying it, so. And the questions of attorneys do not constitute any evidence.
I'll pass the witness.
No further questions of this witness. I ask it should be excused.
Let me, before that.
Yes, sir.
happens, what is the relationship to this witness in the state's case here in this indictment? If any.
She wasn't going to be a witness until she reached out to me and told me that he was trying to purchase her alibi testimony. So I'll be bringing her in the state's case in chief if this case goes to trial.
And you're talking about this burglary of a habitation indictment.
Correct.
In this cause number we're here for.
Anytime a defendant tries to solicit testimony, be it paid or otherwise, I will bring them in to come testify.
Mm-hmm. It is a crime if a person commits the offense of tampering with a witness, which is with intent to influence a witness. He offers, confers, or agrees to confer any benefit on a witness or prospective witness in an official proceeding, such as an indicted case in my court, or he coerces a witness or prospective witness in an official proceeding. And 1, to testify falsely is the first thing out of the box. Or 2, to withhold any testimony, information, documents, or things. And there are 3 other methods of committing such a crime. But I think what your testimony that you're standing behind is section 36.05, subpart A, subpart 1, to testify falsely.
Yes, sir.
And that is a felony of the 3rd degree, which carries with it up to 10 years in prison. If you have prior convictions such as these listed in this indictment, then you're looking at another habitual felony.
Yeah.
All right.
May she step down, Judge?
Yes. Do you need anything more from this lady? You may be seated. What's the state intending to do with that subject matter?
We don't typically like to intake matters at our office. I'll probably refer it to a separate law enforcement agency to finish the investigation and look at determining the filing of this additional criminal charge.
Anything else you want to add on this?
Not as far as evidence goes, Judge.
What do you want to,
Yes, Your Honor, I call Mr. Porter.
the defendant? Dennis, would you please tell the jury that we're going to need for them to relax, and it's going to be about 30 more minutes because of some matters that have arisen. Thank you. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? And do lower your hand. Please. Go ahead.
Did you have a relationship with Mary Griffin?
Yes, sir, from 2018 to 2024.
Okay.
No, 2025.
Okay. And did you talk to her about writing a letter, what was in the back of your truck?
So what has been,
That's a yes or no.
yes,
Then he can ask this next one.
Did you ask her to lie or tell an untruth at any time?
no, sir.
There's been talk about your offer to compensate her. Was that for the letter or for something else?
That was, for the letter, but the compensation was that I would still be there for her whenever she needed me, because she had just, called me and I helped her in the last 3 weeks prior because her son, I had no contact with her since March. And so she called me and, distraught because her son had a heart attack. And if I'd be there for her. And I said, sure. And so compassionately I did. And I gave her money for snacks up there at the hospital, so on and so forth, brought her food. And then afterwards, she said, well, what can I do for you? And I said, well, I need some help. I need you to help me out and be a witness, because you know what was in the back of my truck. And I said, I told her, in not so many words through the text messages, that I would compensate her, which meant I would still be her person, which is in that text messages. Had nothing to do with monetary value.
Did you subsequently, after breaking up with Miss Griffin, get married?
Yes, I did. And I told her I was getting married in November. She tried to call me back to get back with her on the November 24th. I told her there was no way. Too much water under the bridge, too much control, too much trying to just keep me wore down, control. And enough was enough. And I went on to better my life.
So it's it's her fault.
Sir?
It's her fault.
I was I was so controlled that when I was getting my Class A CDL in February, 2 weeks before I went to take my test, she begged me not to take the test, and that she would give me $400 out of each one of her paychecks if I would just take the job that I got, because that way she could continue with the trackers on my truck, and there's no trackers on an 18-wheeler at my job. So therefore, she didn't want me to go anywhere. And I said I couldn't do it anymore, that I want to work. I've been a Boilermaker all my life, and I wanted to work, and I wanted to advance in this company. And I got my Class A CDL. And the day I got my Class A CDL, she left before I even got home from Longview from taking my test. And then there was nothing from March until June. He had a heart attack. She called me out of the blue. I'd be there for her. I said yes. And that was it. And I did not ask for any compensation as far as monetary value to get the letter. She said that she would gladly. And she wrote the letter. I have the letter. I gave it to Mr. Megan. I did not crumple it up. And I did not shoot the finger at her, what she said. It's intact. And there's no pieces from being crumpled up. Since then, she has called and tried to sabotage our relationship. My wife has the text messages, and I've asked her to leave us alone. She knows we got married, and this is why she's doing what she's doing.
Hold on. I'm just. I'm a little confused here. This state's exhibit 1 that's been introduced, these are your statements, right?
Yes, sir. I don't deny any of
Okay.
it. It's just that I did.
Mary, please, are you going to help me or not? Everything else is frivolous. Sounds like whether she helps you or not is of primary importance to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping me. You don't have to. That's why I'm going to compensate. That's the only thing we're dealing with right now.
Yes, there was.
That's pretty insistent.
There was phone calls in between the text messages, and we was talking, and then I would, and then she would get mad and hang up. But in those phone calls.
Well, hold on. I'm just fuzzy. What is it that you need her help with? Since everything else in the world, in your life, and the existence on this planet is frivolous, other than that primary need of yours. What is this primary need?
So that phone call consisted of.
What is your primary need that you're expressing in words here? You're going, please, are you going to help me or not? Everything else is frivolous. This is the most important thing right now in existence in the universe. What is this most important thing?
She asked how she could help, and
no, what is this important thing that she, of what, sir? You're dancing around this issue. Helping you what?
Helping me with this case, because
this case.
She knows I was innocent. She knows I was innocent.
I would compensate your helping me.
Yes, by being her person, and I have that in the text message. I will compensate, which means I will, anytime that anything goes wrong in her life and she needs me, I will be there. She always called me her person. Even the day she called and her son had a heart attack, I said, why you calling me? She said, because you're my person.
Yeah, I know you're making this sound so selfless on your part, but you say, are you going to help me or not? Everything else is frivolous.
Yes,
it's your need.
Talking about relationship.
We can talk over each other, and that would be inappropriate. You're going to keep speaking over me? Let me speak, then you can speak. Number one, it's rude not to, but number two, she has to take all of this down, and she can't take when two people are taking down. Yes. And you seem to be a very aggressive, controlling kind of person, but relax. Okay, you'll get your chance to be heard. Are you going to help me or not? Everything else is frivolous. That's pretty succinct. This is whatever this is that your needs are. If this is your need, it's more important than anything else in the universe, according to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping me. That's the only thing we're dealing with. You're talking about compensating her to help you in this case.
Yes, sir.
You see anything wrong with that? Because when somebody is a witness that may help you, you have a right to get that. And they're subpoenaed and they come under oath, and based upon the sanctions that perjury can bring about, people better tell the truth. They don't get paid for being a witness generally. But what is it you're paying her to say?
I never offered to pay her. I always said.
Wait. That's what I would compensate your helping me. Didn't you say that? There it is.
I didn't mean it monetarily.
Wait. What compensation are you talking about?
In return, my compensation would be to help her anytime she needed me. As I did. With her son.
Just being a wonderful guy.
And that was, yes, and I was.
Okay. Well, no, sir, you've been convicted of felonies twice. That's a character issue. Haven't you? I'm sorry. That's what the grand jury says, that you were convicted of burglary of a building, which is similar to what you're charged with, your burglary of a habitation.
Well,
and then, hold on, and then sexual assault of a child. You were convicted of that, weren't you?
And
do you find that, is that true?
Yes, sir.
Isn't that serious?
It's very serious.
Okay. All right.
But by the second, can I say something now?
Yes.
By the same token, on each one of those cases, it was a finger point, and my lawyer's done nothing. Rife Kimler I sat right there in Walker's court and Wright Kimler denied me and my 5 witnesses to testify, then straight up denied me.
So it's somebody else's fault.
Well, I was begging.
No,
him
no,
to
is it
testify.
yes or no? It's somebody else's fault.
It was Wright's fault.
Okay.
Or it was my fault because I didn't get a better lawyer. I didn't know how to get a
Okay,
lawyer.
but it was somebody who didn't do their job. But you have been convicted twice on two separate serious offenses, and you're saying that wasn't your fault.
No, sir, it wasn't.
Is that right?
I didn't get my day in court.
Sir, were you found guilty? You have a right to appeal. Did you appeal those cases?
Yes, sir.
And what were the results of the appeals? They were affirmed, weren't they?
No, sir. Brian Lane's still working on my.
No, sir. Have they been overturned?
I'm working on it.
Sure. Until they are overturned,
Yes, sir.
a conviction is valid
Yes, sir.
unless it's overturned.
Yes, sir.
I'd like to see the future that you're looking into, but and we're talking about a conviction. First of all, in 1989, that's 30 some odd years ago, 37 years ago. And, that appeal is way out of time. So the only thing you would have would be a writ of habeas corpus. Is that what's being done?
I didn't try it. No, sir. It was a.
So you're not appealing that case?
No, sir.
That's what I thought you inferred to us a little while ago.
No, sir.
All right. Then the next one is 2005. That was over 20 years ago.
Yes.
You don't have much of an appeal at this time. You may have a writ, but an appeal is way overdue.
No, I started the appeal in 2018, 2 years after I got out. And
That
I
was-
earned the money to get it.
Okay, isn't that 8 years ago?
Yes, sir.
Okay, what's the result of it?
I don't know what's happening. Yeah, I
Oh,
was down Brian Lane.
Look, a conviction is valid unless it's overturned. Unless that happens, you can sit there all day long and cry foul, but it's the way it is. But you have 2 convictions,
Yes, sir.
and they make up part of this case and its punishment, which subjects you to 25 to life. Anyway, we can beat this one a while, but State's Exhibit 1, which is part of the record, clearly states, and you've made it clear that you're referring to this case and you're willing to compensate her for help in this case. And that seems pretty clear.
Sure.
What else do you want to ask?
Questions from
The only thing I want to ask you in regards to just this issue, I've got plenty other things I'd like to talk about. But I want to know if you're going to admit that you texted her January 26th of 2026.
A week ago?
Yeah, just a week ago, after you found out about this motion, did you in fact engage in text that lady right after, just like she testified?
I had no idea.
Yes or no?
Yes, but I had no idea she made the complaint. I had no idea. I didn't know who this was. You can ask my lawyer. I had no idea.
You're going to tell me that this
Well,
lawyer.
let him finish, please. Go ahead.
I had no idea. Yes, I've come to him and we thought this whole time it was another woman named Denise that stole $10,000 from her, my wife. I had no idea that it was this person at all.
So it's just ironic that the same day that you talked to him is when you reached out to her.
I reached out to her because I got a letter in the mail that was opened already and on the ground, and it said municipal court in Nederland. And I simply asked if she had a ticket that I'd help her with it.
I don't have any other questions.
With all your troubles, with all these fires, these raging fires that are occurring right now, you were worrying about her traffic, some municipal ticket. That's what you were spending your time on? Is that right? When you have all of this looking at 25 to life? You're saying you stopped what you were doing and were curious about whether she had a municipal city ordinance ticket?
That's what she failed to. It's on the text message that she failed to provide that. Yes.
Things.
Mr. Porter, are you employed? Are you employed?
Yes, sir.
And whatever conditions the judge imposes on a bond, you'll follow those, right?
Yes, sir.
And you'll show up in court when you're supposed to?
Yes, sir.
If nothing further on.
All right. Go ahead. Anything else to add?
No, Judge, you've
Got to
covered
catch up.
a lot of what I wanted to do. So in the nature of time, I'm going to pass.
Summarize. What what relief are you asking? And then Mr. Macon, what you respond to. Go ahead.
Judge, based upon the testimony from both witnesses today, I'm not convinced that there's a bond amount or conditions that can guarantee the safety of one, the witness that just testified, and two, the community in general. In that regard, based upon the motion to increase, I ask that Your Honor revoke the bond, which in my opinion was insufficient, and let's leave him waiting trial. But as for no bond.
Go ahead, Mr. Macon.
You know, we would naturally disagree. We think any bond Mr. Porter made, he would do. He would not contact anyone. He doesn't represent a danger to the community. He's employed.
All right. What is his bond right now?
30,000, Your Honor.
Okay. The court is going to keep you on a bond. Your bond, though, is doubled to $60,000. And you must have a GPS device at all times. Do you have one on you right now? You must have a global positioning device so I know where you are at all times. And you shall have, as a condition of bond, no contact with any witnesses in this case except through your attorney, Mr. Macon. And you can, of course, contact your own witnesses directly, but not witnesses who may be witnesses for the state. And we know that this lady was a witness for the state. Section 36.05 of the Texas Penal Code provides for felony punishment for any person who, with intent to influence a witness, offers, confers, or agrees to confer any benefit or of a witness or prospective witness in any official proceeding to testify falsely. Sir, it's clear, according to her testimony, that's what this is all about. And I'm going to ask the state of Texas to refer this also to consideration for a grand jury review. And the court finds that there is, based upon her testimony, that clearly meets those elements of that crime. The first condition of your bond is don't commit an offense. Any attempt to commit a crime or carrying out the commission of the elements of a crime constitute a violation of that bond. If this court discovers any further failings to follow bond conditions, then we'll bring you right back up here, and then it will your bond will geometrically increase, or it will be disallowed completely, and you'll have to be in custody until such time we have this trial. Are you setting this thing for trial?
Yes,
it is on the trial.
Let's get it done. And I don't want to hear anything about attempts to influence witnesses, work through your attorney. He knows how to do things. That is all.
Well, alrighty, friends, we stumbled into a very, very interesting one there, didn't we? I'll more than likely have more to say on this during the fourth hour when we get into some news and some discussion. But I took notes. Not quite seen anything like that in Stevens Court before. So that was a good watch. Let's change it up, though. Let's go to Louisiana. Looks like the parole board is on the road right now. They're at Loyola.
They on mute?
can't hear him.
We're unmuted. We can't see them on here.
Our first remote location this morning is at Louisiana State Penitentiary. So would the staff at Angola please introduce yourself for the record?
Deputy Warden Rochelle Ambo.
Reginald Admiral, classification.
Carmen Shipley, vendor records. Jody Sturgeon, program consultant.
Okay, thank you. Thanks for hosting us this morning. And our first case there at Angola is Mr. Jacobs. Good morning, Mr. Jacobs.
Good morning.
Would you introduce yourself, sir? Tell us your name and your DOC number.
My name is Zeandre Jacobs. My DOC number is 447048.
Yes, sir. Mr. Jacobs, I'm going to read some identifying information into the record. But first, let me recognize we do have some folks here today. In support, we have Malcolm Matthews and Chris Williams, who'll be speaking on your behalf. I believe they're there with you in Angola. Here with us in New Orleans, we have representing the victim, Jamie Alexander, Yolanda Anders, Roger Dawkins, Roderick Dawkins, DeWanda Dawkins, and also the district attorney, Mr. Philip Terrell. And for those who've indicated they'd like to speak, we'll call on them at the appropriate time. First, let me read the identifying information, then I'm going to turn it over to Mr. Tillis because your case has been assigned to him this morning. So, Mr. Jacobs, you're classified as a third felony offender. You're currently serving a 60-year sentence. You were sentenced April 11, 2006 in Rapides Parish as a habitual offender for manslaughter. You have a parole eligibility date, which was September 7, 2025, and you have a good time release date, October 13, 2064. Is that information correct?
Yes, ma'am.
All right, and I do see we have Mr. Kerry Myers with the Parole Project on Zoom as well. Mr. Tillis?
Okay.
I did.
Okay. Good morning, Mr. Jacobs. How are you?
All right, sir. Real grateful this morning.
Good. Could you tell us why you're incarcerated and what caused you to be incarcerated? And why should we vote to in your favor, please?
Yes, sir. Well, always been my problem. I used to try to, I guess I can say, escape from myself, from my fears of my infidelities, not really knowing what was going to happen next in my life, the trouble, the bad decisions and choices I was making, starting from suspension from school to just straight out quitting, accidents, spending unnecessary finances, the trouble with the law, jumping from job to job, just a lot of chaos and confusion, and my anger. And my anger was angry because I knew I had the potential to do better and be better. But my irrational thinking at that time made me feel as if I was a failure and unable to talk to anyone because I didn't trust anyone and I didn't want to appear weak. So I self-medicated. I drank, I smoked weed, I popped pills, trying to avoid those feelings. And the only thing I was doing was really harboring the pain. And depression sits in, so I began to isolate myself. Some days I didn't want to be around anyone, talk to anyone. Some days I did. Then eventually, after holding all that negative energy in, the worst thing that could possibly happen happened.
What was that?
I ended up taking the life of this beautiful and innocent woman all because I was unable to manage my life. For a long time, for a while, I'll say, I fought with the fact that I had taken a human life. The incident haunted me for years. I continued to get high while incarcerated, still trying to escape the reality of what I had done. But the remorse always come back. What I wanted was to find peace with myself. So after trying on my own unsuccessfully, I asked for help. The serenity prayer states, God, grant me the serenity to accept the things I cannot change, the courage to change the things that I can, and the wisdom to know the difference. By me allowing my life to become unmanageable, I took a human life. And I cannot change that. So I had to learn to accept it. But I was able to change from the person that I was.
Is that it?
No, sir. I'm sorry. I took a human life. And by doing so, I caused unimaginable and permanent pain to the victim's family, friends, and community. There's no excuse for my action. I take full and complete responsibility for them. My time here at Angola has been about one central goal: to ensure that the person who committed that terrible act is not the same person sitting before you today. My rehabilitation was my primary focus. I want to make sure my time spent was not time wasted. And even though I had an addiction problem, and addiction is a horrible disease, our lives are still predicated or determined by the choices we make. And on September the 5th, 2005, I made the worst choice imaginable. So instead of continue making these bad choices, I knew it was time for me to make some right choices. So that's when I got myself involved in different programmings, and surrounded myself around positive individuals, stopped using, and was able to share and trust with people. I also have a decent disciplinary record, 4 write-ups in 20 years. I think that shows I'm able to live within a set of rules and conduct myself with respect. I also have held the same job for over 16 years, which shows I can maintain employment. If released, I plan on living a quiet, productive, and lawful life. Plan on working to help support my family any way they may need, because they've always been there for me. I understand my freedom is a privilege and not a right. And I will not violate that trust you place in me. I'm not asking you to forget my crime. I live with the memory of it every day. But I wanted you to see that I have worked towards reform or rebuilding myself. Even though I can never bring Teresa back, I will spend the rest of my life proving to you that your decision to grant me a second chance was not a mistake. Thank you.
Thank you so much. We're going to come back with some more questions, but Warden, can you tell us anything about Mr. Jacobs, please?
Yes, Mr. Jacobs is a minimum aid trustee. He's assigned to graphic design. Like he said, he had a total of 4 DB reports his whole time here, the last one being in 2017. He has a degree in graphic communication. He has taken Cage Your Rage, Substance Abuse, 100 Hours, Inside Out Dad, Thinking for a Change. He did the Victim Awareness Accountability Letter. He participated in the STAR Substance Abuse Program. He just finished that on June 30th of 2025. He has a GED. He participated in a New Men Sober Group, and he also participated in 12 Steps Alcoholics Anonymous. We haven't had no problems here with Mr. Jacob. He has been a model inmate.
How long has he been a trustee?
He has been a trustee since 2014.
Thank you so much, Warden.
You're welcome.
Yeah, we'll, next, before we continue with our interview with Mr. Jacobs, we're going to hear from his supporters. Could we hear first from Mr. Malcolm Matthews?
Yes, my name is Malcolm Matthews. I'm from West Monroe. I speak today in support of Zeandre at his parole hearing. I want to thank him for the honor of asking me to do this, and I also want to thank the board for listening to me today. I also want to thank the board for the tireless work you do in fairly deciding on the merits of cases that come before you. I have known Zeandre since last August, which is not a long time, but we met face to face today for the first time, actually. However, since August, our communications have been steady, sincere, and open. He's been part of the fellowship that I helped facilitate that serves as an outreach to 100 men here at Angola and other satellite prisons, as well as one woman at the Women's Institute. We mail out sermon notes each week from Dr. Patrick Mead of our Safe Harbor Church in Tennessee. Zeandre has been an active participant since day one, beginning in August, communicating his questions and comments. And he and I have talked also recently on the phone quite often. So I feel close to him, and I'm thankful I got to meet him today finally. Zeandre was recommended to me, and this stands out to me because he was recommended by a mutual good friend of ours, Mr. Milton Williams, who himself last December 3rd was granted parole here in this same room and has his release, it was released from Angola. Milton and I speak almost daily. He told me that Zeandre is one of the best men he knew while he was incarcerated here at Angola. And then he further went on to say that of every man that he knew in prison who also knew Zeandre, every one of them had high regard for Z. I include that in my comments today because it speaks volumes to me that if he's held in such esteem where he is now, it stands to reason in my mind that he can carry that trait outside the wires of the prison and into society when he's released. Early on, Zeandre expressed to me, as he's expressed already this morning here, his remorse for the needless loss of Ms. Dawkins' life that he caused, and for the accompanying grief that has been ongoing for so many of her friends, her family, and his family and friends. He had a serious alcohol problem which contributed to the downward spiral of his life. He's talked about that. But he realizes and states that alcohol did not commit the crime. He committed the crime to take her life. And he faces that fact and owns responsibility for what happened. I'm in possession of his impressive packet of certificates of training and self-help classes that he's completed. And I know you have it too. I feel like he has used his time well and has redeemed his time well and redeemed himself as a human being. I think he's faced his demons and sought help to keep them out of his life going forward. And upon release, since alcoholism was a problem for him, upon release, he plans to join and maintain active attendance and participation with AA or Celebrate Recovery or a similar program to that to address that problem. So he can help himself and also help others in that same program. He and I had an instant rapport in that I'm a retired graphic designer, and that's what he's done at the prison for so many years, working in the area of graphics and signage and various projects. He's worked for the state DMV signage, municipality street signage, law enforcement decals, uniforms, t-shirts, as well as logo designs. These were done for several state agencies, police departments, and universities. In the area of logo design, he recently designed the STAR program, which has been mentioned already here at Angola, and the design was then adopted at the state level. And he's got that logo on his shirt today. I thought that was cool that he wore that shirt with the STAR logo that he designed. He wants to remain in that vocation upon his release. To that end, I offer him my name as a reference for entrance into schooling or employment after his release. He wisely, however, tells me that wisely he has taken other training. I think a commercial driver's license and some other training that he's completed to be job options as backups should that primary plan and graphics not work out immediately for him. So he's got his backups, and I think that's smart. So I plead for you to consider the accomplishments of this good man and the changes he has made toward a good life and service to others, and vote unanimously to grant his parole today. Thank you.
Yes, sir. Thank you, Mr. Matthews. We appreciate hearing from you. Mr. Williams, Chris Williams.
Yes, ma'am. How y'all doing this morning?
Good, thank you.
All right. My name is Chris Williams. I'm speaking on behalf of my longtime friend, Zeandre Jacobs. I know him as Tootie. That was his nickname, who I know for over 40 years. He has been a close friend since I was 9 or 10. From a young age, Zeandre stood out as someone who was quiet, intelligent, and dependable. He had his way of figuring out things, and whatever problems we had, we can go to him and he gave us some sound advice. He naturally became the leader of the group, and I looked up to him. Usually the quiet one always be the one that you stand out in the back, but he was in the front, but he was the quiet one. As we grew older, Zeandre continued to set a positive example. He was the first among us to learn how to drive. He was the first to get married. And personally, I witnessed how well he cared and took care of his family and his kids. He always worked hard and consistently held a job, taking pride, providing for those who depended on him. One moment stuck with me and what he did for me. I needed $100 to secure my first car. The bank was closed. I couldn't get nowhere to get money, but I thought about my friend. I asked Zeandre, can I borrow $100? Because of course he had a job. He said, with no hesitation, he let me borrow it. He always was a hard worker. The act of kindness meant more to me probably than I realized the type of person he always was. Since incarcerated, Zeandre and I speak almost every Sunday. Our conversation, we focus on family, friends, and our kids, and the plans for his future. He speaks with hope and determination. He has shared his desire to pursue his career in graphic design or obtain a CDL license driving trucks. More than anything, he looked forward to reuniting with his family and being present for his 3 kids and his grandchildren. I truly believe he has grown to change for the better. He has a strong support from his family and friends, and he will continue to have strong support from us when he returns home. As a friend for 4 decades, I respectfully ask you to find in your hearts to grant Zeandre Jacobs a second chance. I believe he will use the opportunity to live responsible, productive, and a positive life. God bless.
Thank you, Mr. Williams. Could we hear from the Parole Project, please?
Good morning, Kerry Myers with Louisiana Parole Project. Here from Mr. Jacobs. Parole Project has accepted Mr. Jacobs as a client based on his institutional record. That includes job stability, 16 years on the job, 10 years of trustee status. He earned his GED, as you've heard, his disciplinary record, his participation in STAR as a new men volunteer mentor, his 330 hours of CTRP credit. He's just demonstrated what Parole Project is about, and that's the capacity for people to change. So should this board grant his parole today, we will provide him the transitional services that someone who served 20 years in prison is needing when they return. That is going to include transitional housing, programming, life skills, financial evaluations by our social workers for his substance abuse and recommendations to be followed upon that. We will assist him in placing in any AA or other programs that he can join. So based on that institutional record, Parole Project asks this board to consider granting his parole today into our program.
Thank you. Thank you. We appreciate the work that the Parole Project does. Now we'll move on and hear from the opposition. And we have Ms. DeWanda Dawkins who'd like to say a few words. Amanda?
Good morning.
Morning.
I am Amanda Andrus. I am Miss Teresa's daughter-in-law, but I also, before I was her daughter-in-law, I grew up with her, so I knew her. I'm here to strongly oppose his release from prison, as I do believe he does not deserve the opportunity for parole or to re-enter society. Teresa Dawkins was a beloved mother, grandmother, sister, aunt, and friend. Her murder has left an inconsolable mark on all of our lives. She was a kind and caring woman who dedicated her life to her family, and her loss is deeply felt by her 5 children, 13 grandchildren, and 2 great-grandchildren. The pain of her absence is something we carry every day, a void that can never truly be filled. Her death is also profoundly affected her brothers, sisters, nieces, nephews, and cousins who continue to mourn her loss and the life cut short. The trauma and grief we experience are compounded by the fact that her murderer remains a threat to society, and his potential release would cause further pain and suffering for all who loved her. While I acknowledge the importance of rehabilitation and second chances, I believe that justice for Teresa and her family requires that he remains incarcerated. The impact of his actions is irreversible, and I sincerely hope that the parole board considers the lasting harm done by his crime. Thank you for allowing me to share my heartfelt feelings on this matter.
Thank you for sharing those feelings. I think we'll hear from the DA now, Mr. Terrell.
Good morning, members of the parole board. Philip Terrell on behalf of the state of Louisiana, Ms. Teresa Dawkins, and the surviving victims. On September the 9th, 2005, Mr. Jacobs took the life of Teresa Dawkins. On that day, the Alexandria Police Department was called to the Alexandria Zoo. An employee reported finding a pool of blood, some female clothing that was torn, and some money. The APD officer examined the same and asked to view video surveillance. Detectives were called out to the scene, And the video showed a dark colored vehicle arrive between a zoo building and a male exit the vehicle. Next, a female walked around to the front of the vehicle and fell to the ground. She got up but fell again. Then the male was seen dragging the female by her legs back to the car and placing her in the trunk of the car. Another APD officer was patrolling near Gene Ball Drive, which is some distance away from the Alexandria Zoo, about 5 o'clock on the morning of the 6th. And he saw a car that he thought was being operated suspiciously. Slow down, speed up. And so he got behind it and was able to get the license number, but that APD officer received a call of a burglary in process, so he had to leave and go to that. Enough of the information off the license plate number for the detectives to trace it back to another person who told the detectives that Mr. Jacobs was allowed to use it, that particular vehicle. Then when the detectives contacted Mr. Jacobs the next day, he confessed to murdering Miss Dawkins and trying to attempt to secret her body on Gene Ball Drive in Alexandria. His statement to the detectives is particularly telling in this as to his motive. I don't know what came over me. I just had the urge to kill her. And the way he said he killed her was that he stabbed her several times as she was trying to run away from him. He caught up with her, stabbed her some more, beat her with a pistol about the head, and then shot her twice. Mr. Jacobs has had other run-ins with the law, as evidenced by the fact that he is was adjudged a habitual offender, and he pled to that as well. Mr. Jacobs was had a violent juvenile record. Mr. Jacobs was convicted of DWI 1, 2, and 3. Mr. Jacobs was pled guilty to prior to this incident, to a previous attempted murder. So he didn't get it right the first time, but he tried it, but he did the second. We are all about second chances. The habitual offender bill that he pled to says at the bottom, without benefit of parole, probation, or suspension of sentence, got 60 years with that concurrent with his manslaughter. He pled to all those things. There is a contract between these victims and the state of Louisiana. We promised them that we would send him to prison for 60 years, and we did. And I would submit, ladies and gentlemen, that it would be absolutely unfair to these fine people who weren't, one of them who works for the Department of Corrections. She was 14 years old when her mother was murdered. She didn't have a chance. Miss Teresa Dawkins didn't have a second chance, and these folks here did not have a chance to be with them. As to Mr. Jacobs' substance abuse, there are millions and millions of alcoholics throughout the world who don't commit any crimes, much less a murder and an attempted murder. He referred to the Serenity Prayer. Also, one of the tenets of any appropriate substance abuse treatment, particularly AA and NA, is that the person working in that program, the member of that program, must accept responsibility for their actions. He was given a responsibility for his action, that action 60 years. So I don't want to belabor, y'all familiar with the facts. This is not a drug case or a simple burglary. This is a murder by a person who attempted to commit a murder before and went to prison for 7 years on that. So what I would submit that for purposes of public safety, I would also submit that because what I feel like is a compact that the system and our office made with these folks, that he remain in prison. Thank you very much for listening to me. I appreciate it.
Thank you, Mr. Terrell. All right, Mr. Tillis, you want to? continue your interview?
Yes.
Oh, I'm sorry. I don't know. Was there anybody else that needed to speak? I think not.
Mr. Jacob, how old were you when this crime happened?
31.
You were 31. We see, and I saw where you took a lot of classes. Which one impacted you the most?
I'd have to say the STR program. And the reason being, early in the morning, Ms. Laura would do something called a check-in. She'll go around the group and ask everyone how they was feeling. And it gave you the opportunity to state, how you were feeling, and if you had something on your mind to release it or whatnot. And I thought that was a good thing because as we go through our day-to-day and interact with one another, we always see the exterior of a person, the outside. We never really know what's going on the inside of a person. Something may look good on the outside, but it may be, tore up on the inside. The way you think, how you feel determines how you think. And how you think will determine the actions brought on by those feelings, whether they're good or bad. And I thought that exercise was real good because it taught communication, trust, and it helped build empathy. You were able to empathize with the next person. And I for one, started doing a daily check-in on myself because I knew how the effects of holding in those bad feelings, what it can do, what it can lead to. So it's good to share, and how you do that is by trusting someone, and you build that by communication.
Thank you. At what time I think you stated it earlier, what time did you realize when you were incarcerated that you needed to change your life?
Around in 2008. Well, I knew earlier when I was first incarcerated, is the reality of what I had done. The murder was just eating me up. That's why I was continuing to get high. But around 2008 is when I really came around and just cut ties on everything.
And that's when you started trying to rehabilitate yourself to change your life, to do better?
Yes, sir. Really focused on it. I had started in 2007 when I first got my GED, but that's when I really got focused in 2008.
I see where you had a lot of classes. If you were released, what would you do? Where would you go? Where would you live?
Well, I was planning on staying in Baton Rouge, but I have down for to stay with my mother in Rapides Parish, but I was trying to see if I could stay on longer with the parole board until financially able to get my own spot, because that's where I really would prefer to be in Baton Rouge. But I plan on taking an online course to get my bachelor's degree in graphic design. That's where I can work from home and self-employment if possible. I haven't gotten my CDL. I plan on getting my CDL when I get out. Because I believe we never have too many options. But I also plan on finding an AA group to sell into, to continue my recovery, and any other support group that I might come across that can help in my situation, or that I might can help.
Okay, you've done well. Any of my colleagues have any questions?
Mr. Prater?
No, I don't have any questions.
I have a couple of questions.
Yes, ma'am.
Mr. Jacobs, at the time of this crime, were you married?
Yes, ma'am.
What was your relationship with Miss Dawkins?
So I didn't know her.
You didn't know her.
No, ma'am.
And had you been in the drug court program previously?
Yes, ma'am. I got in there in 2003, and I had just finished in 2005, April 2005, I think it was.
Yeah, so you completed drug court.
Yes, ma'am.
And then, but
But
then
at the time,
you
I,
continue doing the same behavior in terms
yes,
of
ma'am.
your
That was what I was
substance
about to.
abuse.
That's what I was about to tell you. I wasn't ready to stop. I was still with the foolishness.
So at what point in your incarceration did you come to terms with what you did? Because you still really haven't told us what you did. We heard from the DA and we heard
Yes,
from
ma'am.
Ms. Dawkins' family, but, and I don't want you to say it now, but I'm just wondering why you didn't, you weren't real forthcoming about what you really did.
Oh, well, I thought you was, when you first asked about what led up to it, that's why I was going into that there.
Well, yeah, that was helpful too, but you never said what you did. Let's
Yes,
move
ma'am.
on. So, the warden said you did the victim accountability program. What
Yes,
did you
ma'am.
get out of that?
Well, I learned about the empathy more than anything was stood out the most, and that's dealing with for me, I do a lot of people trusting me to come to me when they have their problems or whatnot, and listening to someone share their feelings, and also being able to share your feelings, it helps build empathy. So that's the main thing I was.
Good. So what do you think? Have you had any victim impact training?
Meaning kind of.
Victim aware and accountability letter. You didn't have anything.
Yes, I'm confused with the question, the victim impact.
Yeah, that's a little different.
Oh, okay. I'm sorry,
What
ma'am.
was
No,
the impact on what in your mind was the impact on your victim and the surviving family members?
I know for a fact I heard him. I know that's why I say it was a irreparable and permanent pain. I know that's a pain that would never go away, and that's why I say that I mean now I cannot change that. That's why person I am now. I've changed from that person who committed that horrible act.
Okay. All right.
I killed her. I'm very sorry for that. I'm completely sorry. But the person who done that is not the same person sitting here right now.
I believe that. All right. Thank you. Any other questions? All right. I don't see any other questions, so I think we're prepared to vote. Mr. Tillis?
Mr. Jacob, I see a lot of change in you, and I see some remorsefulness, and you're on a good path. I'm impressed. But you've done 20 years of a 60-year crime, and due to law enforcement and family opposition, my vote today is going to be to deny.
Mr. Prater?
I concur.
Mr. Jacobs, I too believe that you have a path forward. You're doing the right things. But based on what we've heard here today and the length of time you have served is insufficient. My vote today is to deny your parole. But I want to encourage you to stay the course, continue doing community service within your little prison environment, and reapply whenever you're eligible to do so. Good luck to you, sir.
Thank you.
All right, I think that's the right choice and probably not a surprise. Let me see if this will work. Denied. I think it worked. You'll tell me if you heard the denied compliments of Michael Groff. Which, by the way, Michael Groff and I, in the blind tonight, 7 p.m. Eastern, 4 p.m. Pacific. There's a link in the chat. It's pinned up top. If you are new to the channel, Michael is our on-staff weatherman for lack of a better way to put it, guest host when I can't do this show, and he also joins us on Sidebar, our panel show on Tuesday and Thursday nights. But In the Blind is a new thing. It has nothing to do with court, but it's all sorts of fun. So if you could, go over there, subscribe to that channel, and join us tonight, because it's a lot of fun, that show is. Let's go Michigan Judge Mom.
Today, Your Honor, I appear as embassy counsel on behalf and with my client, appears to my right, and this is then set for his arraignment pretrial. So please state your name for the record loudly. Gage Abrams.
Okay, and so today is the date scheduled for the arraignment and pretrial, as counsel stated, and as to the arraignment.
As to arraignment, Your Honor, I've had the opportunity to explain to my client the nature of both charges that he's charged with. He understands them both, all possible consequences, sentencings, and effects, be it from this court or any administrative agency. He understands those. At this time, Your Honor, we waive formal reading stand. You ask for a plea of not guilty.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial.
Your Honor, after speaking to the prosecutor, my client wishes to avail himself of the offer and that he will plead guilty to the amended charge of operating while visibly impaired by alcohol. He understands what that entails. And Your Honor, if that plea is in fact accepted, he'll also plead responsible to the amended charge of no proof of insurance, as today he showed me valid proof of insurance. And Your Honor, the prosecutor's motion will be dismissed the two original charges upon the acceptance of the plea, as I've stated. With that, Your Honor, we're ready for the court's examination.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? And you heard the plea that was placed on the record, correct, sir?
Yes.
You may lower your hand. And as to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, please.
And you understand all of those rights?
Yes, please.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes, please.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes, please.
Knowing all of that, do you want to continue with your plea?
Yes, please.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, please.
Any immigration issues? Counsel, please go to your client.
Mr. Abrams, on or about January 25th, 2026, approximately 3 a.m. Were you operating a motor vehicle in the city of Wyandotte? Yes, sir. And prior to operating that vehicle, had you consumed alcoholic beverages? Yes, sir. You tell the court what you drank and how much?
A handful of.
I
had a handful of IPAs.
And they're called Voodoo Rangers. Is that an alcoholic?
There's no talking in court.
Yes, sir.
Sorry.
Is that an alcoholic beverage?
Yes, sir.
And you consumed a few of those, correct?
Yes, sir.
That traditionally, not being a beer drinker, but I've heard IPA beers are stronger than regular beer. Is that correct?
Yes, sir.
Okay. It didn't take long for you to feel the effects of it, correct?
Yes.
In fact, you drove in a way that you were following, police said, is following too close to the vehicle ahead of you. Is that correct?
Yes, sir.
You don't normally drive like that, do you?
Not at all.
Do you believe that the alcohol contributed to that decision to drive too closely?
Yes, sir.
And after you were arrested, did you take a chemical test at the police station?
Yes, sir.
Breathalyzer, correct?
Yes.
We stipulate and enter into the record that the result was 0.227 and 0.235.
Yes, sir.
I'm satisfied. Also, this is the insurance. Did you fail to show the police officer valid proof of insurance at the time?
Yes, sir.
But now it's been corrected. Is that correct?
Yes, sir.
I'm satisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will dismiss the original charge per the plea agreement, the original two charges. And as to bond counsel.
Your Honor, my client has posted a $500 bond. He's not on probation or parole, nothing pending. And Your Honor, tell the court where you're working, please.
I work at Target full-time and I also go to school for my bachelor's in computer science.
And nothing.
Bachelor's with what?
Computer science.
Okay, and where do you attend school, sir?
Southern New Hampshire University.
So that's online?
Yes.
Presumably not. commuting to southern New
No,
Hampshire? Okay.
We asked for the bond to continue, Your Honor. I believe they'll reappear.
If you're to test right now, sir, what's in your system?
Cannabis.
Do you have a valid prescription for that, sir?
No.
When's the last time you used it?
Last week.
So you're not still under the influence?
No.
Moving forward, you're not to possess or consume any alcohol or drugs that are not prescribed. So your level is extremely high, and you're fortunate you didn't injure or kill somebody or otherwise.
I agree with you. It was a very, very stupid decision.
The court's going to continue your cash bond. You're not on the bond in any other jurisdiction, are you, sir?
No.
What's happening with your matter in River Rouge?
That nothing ever really came from it. It was my girlfriend and I, or my ex-girlfriend and I had gotten to a little bit of a tiff. We used.
I don't need no factual information, sir, but you were charged with felony burglary, so that's not proceeding forward?
No, it was a misunderstanding.
Okay. And you're not out on bond in any other jurisdiction?
No, ma'am.
The court's going to order your cash bond to continue. You are not to possess or consume any alcohol or drugs unless prescribed. You are to have a sober link through the Wayne County Jail, testing 6 times per day. So you can do that. Where you report on your own, sir. You don't have to be taken into custody and transported down. So you're going to go over to probation. You're going to get the information regarding the sober link, and when you have to go report to get that, and you'll get your next steps as well. Okay. All right. Have a good day. Thank you. Where's Mr. DeVoy?
Okie dokie, friends. I'm going to take us back to Louisiana. We're going to do the parole board one more time. And then after that, I mean, it's going to go into hour 4 a little bit, I'm sure. But then after that, we'll have some discussion, because I want to talk a little bit about the drunk lady in McNally's court today. Definitely talk about the guy in Stevens court. And I have a couple of interesting legal court-related news stories to share with you. But let's go to the board one more time.
Valenzuela there also?
She's not in the room. She's meeting with another client, Ms. Renanza.
Okay, thank you. So we have there at Angola in support, April Rodman, Mr. Fuller's sister, a brother Jason, his mother Ms. Barbara Fuller, sister Delshonda Fuller, and another brother Robert Washington. On Zoom, you'll see we have Ron Hicks. And also here with us, we have the Parole Project, Mr. Andrew Hunley, who will be speaking in support. At the DOC headquarters in Baton Rouge, which is usually where we are located, there is a room full of support. We have Taronda Woodard, Carl Garrett Davis, Chandrika Diggs, Terrence Wynn, Dwayne Jett. I believe they're all with pipes. Promise of Justice, Sarah Gonzalo, Michael Cahoon, and also Kara Crutcher, an attorney who are there in support. And for those who've indicated they want to speak, we'll call on them at the appropriate time and we'll allow them to do so. First, Mr. Fuller, I'm going to read some identifying information into the record and ask you to verify if it's correct.
Yes, ma'am.
So you are classified as a first felony offender.
Yes, ma'am.
You had a resentencing date in Caddo Parish in October of 2016 on a second-degree murder conviction. You're serving a life sentence with the eligibility of parole. So you were resentenced in 2016 to give you the parole eligibility. Is that right?
Yes, ma'am.
So the parole eligibility date is December 6, 2020. Is that your understanding?
Yes, ma'am.
Okay. And so I'm sure Mr. Lancaster has explained the process, but your case has been assigned to me. So I'm going to ask you a couple of questions. We'll hear from the warden and those who are in favor and support. And we'll hear from Mr. Lancaster, and then we'll have some more questions for you after everybody speaks. So first, just tell us Why you're in jail?
I'm incarcerated because as a 17-year-old kid, I'm I made a decision as a kid to first disrespect my mama. She woke me up for school one morning and she thought I was going to school. And I skipped school, took over from girl's house. In the process of me skipping school, I got with a friend named Kendra Williams. And I took him with me. We was doing drugs, smoking weed, and we supposed to been going over some girl's house. And in the process of us going over some girl's house, Mr. Willie Graham. Mr. Willie Graham lost his life because of a decision I made to first skip school and then hang with him. Mr. Willie Graham lost his life because of that. And I'm responsible for that. Because if I wouldn't have did that, Mr. Willie Graham would have never lost his life like that. And to the victim, everybody that he left behind. And I'm sorry. I know I was a kid then. I know I was young. Man, I am so sorry. And I know I can't change that. If I can breathe life back into Mr. Willie Graham, I would in a heartbeat. And I know I can't. But I just want to say, man, I'm so sorry for the mistakes I made as a kid. I know I made mistakes in life. I know I didn't make the right decisions all the time. I made a lot of them. Even here, since I've been incarcerated, I didn't always do the right thing. For the life that was taken and me being responsible for that, I'm so sorry. But that's why I'm incarcerated on this murder charge.
Okay. We'll have some more questions for you in a little bit. Could we hear from the Parole Project, please?
Good morning, Andrew Hunley with Louisiana Parole Project. Here to confirm that James Fuller is a client of our organization. We've been working with him several years. I know his attorneys provided a brief and we'll give testimony later about his accomplishments. I can tell you our organization's committed to his reentry in the event that he is released based on his institutional record. We believe that all he has done, especially the programming that he started before he was parole eligible, before Miller and Montgomery, he started that track towards rehabilitation. It wasn't always a straight path, but he started it long before he was ever parole eligible. And even whenever he was denied parole, he continued to take additional programming. And he is a leader within the prison today. We can tell you that he recognizes that the best reentry plan isn't to reside in Caddo Parish, based on that's where he caused considerable harm. Parole Project's willing to take him into our reentry program in the Baton Rouge area and give him long-term residence as he works towards his reentry in the Baton Rouge area and not to return to a residence in Caddo Parish. If he's released to us, in addition to housing, we commit to long-term case management. As the board's aware, our organization has done the bulk of the reentry for Louisiana's juvenile lifers, and by and large, they've been ultimately successful, and we've been able to create a community of support for him based on his employable skills and the age he is now. We feel like this is the point where he can be released. He's still young enough to start a career, earn, and work towards self-sufficiency. In short, our organization's committed to provide long-term case management and support if he is granted release by this board today, and I stand by for any questions you may have about his reentry plan. Thank you.
Thank you. Thank you. Mr. Hicks, Ron Hicks, please.
Good morning to this honorable board. Thank you for giving me the opportunity to speak on behalf of Mr. James Fuller. I have known James for many, many years and seen how his life has been in a transition of growth from a perspective of understanding where he went wrong at in his life and trying to make the right decisions and put himself in the right place to get the help needed to be rehabilitated. Mr. Fuller, I consider him as my spiritual son. I've provided spiritual encouragement to him, spiritual counseling, heart-to-heart felt talks about how to move forward, how to be the person that God created him to be. And through those conversations that I've had over the years with Mr. Fuller, I've seen the progress that he's made. He's completed successfully a lot of the DOC-approved programs within the prison. These programs address rehabilitation, they address personal responsibility, they address positive decision-making, which is very reflective in Mr. Fuller's package, which Mr. Lancaster will talk about later. He's just demonstrated growth, continual growth, not growth and then stop, but a continual process of growing as an individual, with the understanding that he can't undo the things that he's done, but he can be a person that can help shape the lives of other people in the future. Not only did Mr. Fuller take these programs, but now Mr. Fuller is also providing, as a facilitator, guidance with other inmates, bringing them through the programs that was so helpful to him to get on the right path and understand the destructive nature that he once exhibited. Now being a more productive person, Mr. Fuller is guiding other individuals in that process. As you've noted, Ms. Renasser, at the beginning of your opening, you acknowledged the support that he had as relates to family members. He has a solid family support system that's backing him. And as Mr. Andrew Huntley has stated with the Louisiana Parole Project, support from the Louisiana Parole Project is a plus. And I'm going to come alongside in any way that I can spiritually to help Mr. Fuller if the board sees fit to grant his parole today. I will stand by him. I will encourage him. I will continue to be a spiritual support and a person that will speak directly to him and try my best to guide Mr. Fuller in a direction that is so needed in our society to help other individuals, other young people to get on the right path. We need a Mr. Fuller here in Baton Rouge or wherever the board sees fit for him to live, to help other young individuals see the destructive nature of their behavior and get on the right path. And I think Mr. Fuller will be a great person to fulfill those obligations. In conclusion, I want to say that Mr. Fuller's rehabilitation, his leadership, his strong family support system demonstrate that he's ready for parole and prepared for success upon his release. Thank you so much for giving me the opportunity to speak on behalf of Mr. Fuller. God blessings.
Thank you, Mr. Hicks. And there at Angola, we have Mr. Fuller's sister, April Rodman.
Thank you.
You can sit down.
You said I should hear you.
They can hear.
Okay.
Hello, my name is April Fuller Redmond, and I am the sister of James Lee Fuller. I am writing strongly in support my brother's character. Having known James Fuller my entire life, I have maintained contact through phone calls and visitation during his time of being incarcerated. As I always remember the role James upheld in my life as a big brother, I must say that has never changed. I am most proud of the many achievements James has been able to accomplish despite of his situation. Just to name a few, James has received his GED, welding certifications, taken fatherhood classes without even being a father. That alone represents the type of love James withholds within his heart for not only people, but children as well. I have personally observed him being active in the work release program and highly looked up to by other inmates during visits while at Angola prison. Leadership has always been instilled in James from our growing up days when our mother would have to leave for work and James was left in charge over my other younger sibling and I. Even as a young child, I have yet to witness James or even known of him to have had any altercations with anyone of any sort. There is one thing I know about James. Once he put his mind to it, he would do it. I recall one of our most important conversations we had was him getting to know God. James made me a promise that he would cast all his cares upon the Lord and seek to follow God's will for his life. Without a shadow of a doubt, James held on to that promise, and the proof of that is us here today on James' behalf at this parole hearing. Upon release, I am fully and faithfully committed to supporting James Lee Fuller's reintegration into society. My main focus will be to take James on a visit to our family's church, United Outreach in Bossier City, Louisiana, to allow him the opportunity to be reconnected to God first by baptism. Everything else will fall in place under God's will for James' life. Thank you for allowing me to speak on my brother's behalf.
Yes, ma'am. Thank you for your remarks. Warden Ambo, could you tell us anything about Mr. Fuller?
Okay, I can tell you that Mr. Fuller has been a model inmate. He does have paperwork saying that he completed a victim impact letter. He just completed it on 29th of January. I had it faxed over to you. Other than the welding, the STAR program, you know, he got his GED, Malachi Dad, what everybody else, you know, said to y'all and stuff like that. All I can say is that, you know, we have no problem here with James at Louisiana State Penitentiary. And he has been a model inmate and he's ready to go back into society.
Thank you. All right, Mr. Lancaster, we'd like to hear your presentation.
Thank you, Ms. Renata, Mr. Tillis, and Mr. Prater. As mentioned, James was 17 years old at the time the crime occurred. He spent 30 years here at Angola. He's now 47 years old. If you look at his time that he spent in prison, it does show a path where now he demonstrates maturity and rehabilitation. He's a Class A trustee here at Angola. That's the highest status, minimum status here. He is a resident of Camp F, which is the trustee camp. Since his last parole hearing, which was in 2020, he's done a number of things, and the committee at that time encouraged him to do more work, and he's done that. Primarily, he has participated in the STAR program, Substance Treatment and Recovery Program, and now he currently serves as a facilitator 4 days a week at the main prison for other people coming through that program. So it's been extremely impactful for him, and he's been able to share that with other prisoners who are entering that program. So I hope the committee has a chance to ask him some questions about his experience in the STAR program and as a facilitator. He's taken victim awareness. As mentioned, he's recently completed it. Thinking for a change again. He's got his carpentry certification since his last parole hearing, adding that to his welding certification, and he's continued to participate in Alcoholics Anonymous. All total, if you look at his institutional record, he's taken 13 programs that qualify for CTRP credit. Even though, with his sentence, he doesn't accumulate CTRP credit, but he has taken those courses. He also volunteers for the Veterans Club at Camp F, which is a significant experience for him. He's not a veteran himself, but he's been doing that for a number of years. In that, he's found a sense of community. We know that juvenile lifers who have been released have been very successful on the outside. Part of that is the fact they have housing. Mr. Fuller will have that through the parole project. He'll have a job. The parole project will get him work. They also, a sense of community. He's built that sense of community here at Angola, and that will continue on the outside. Another thing that I think is important just to note is the level of support he has, both family support and community support. Those at headquarters who are in full support of him, as well as his family here. And of course, he'll have the support of the parole project. People in the institution who know him, Lori Stone, who is the STAR program coordinator in Mr. Fuller's annual review, commented that Mr. Fuller exceeds expectations, is enthusiastic and trustworthy. Colonel Fuge, security supervisor, commented that Mr. Fuller is no security risk at this time and follows penitentiary rules. Sherry Barton, the ARDC supervisor, commented that Mr. Fuller is polite, respectable, dependable, friendly, and has a calm demeanor. Mr. Fuller, I think, demonstrates that he'll be successful on the outside, and we pray that this committee grants him parole to continue to serve the remainder of his sentence under supervision in the community and continue to demonstrate that he is compliant with rules and has changed and will be successful. Thank you.
Thank you. And earlier, I failed to mention that we do have a representative from the Caddo District Attorney's Office, the Victim Assistance Coordinator, Miss Leona Fitzgerald, and she would like to speak in opposition, and we'd like to hear from you now, Miss Fitzgerald.
Good
morning. Yes, I'm Leona Fitzgerald, and I'm here on behalf of the District Attorney, James Stewart, and the District Attorney's Office. Our office is opposed in this situation, and I do appreciate Mr. Fuller's comments and his acceptance of accountability for what happened. I don't want to go too deep into the facts of the case for that reason, but I do feel like I have to point out just how shocking and senseless this offense was. Mr. Willie Graham was a member of our community. This happened in broad daylight around 2:00 in the afternoon. There were eyewitnesses to this shooting, and I realized that he was 17 years old, but surely he knew at 17 that this was unacceptable. And basically, he chased Mr. Graham down as he ran away. Life, and Mr. Graham was shot in the back twice, and he was still able to get up and run more for his life, and was able to flag down a stranger who drove him to the emergency room. So this was just sort of like stalking an animal, it seems. I'm glad to see that Mr. Fuller has his GED and has experience with welding, but I can't ignore his prison behavior, his 26 write-ups in the amount of time that he's been in prison. And yes, for the past 5 years or so, it looks like he has a clean disciplinary record, but it was terrible before that. And I couldn't help but notice that Mr. Fuller was resentenced in 2016, and at that point, he became eligible for parole. And that is when there was a great uptick in his disciplinary behavior getting better. And also all the programs, I'm looking at these certificates here and all the classes that he took. And that looks like that was in 2017. So my question is, what was Mr. Fuller doing from 1996 until 2016? Was he taking classes? I have 2 certificates of completion that predate 2017. I have copies of 15 certificates since 2017. So in my mind, that's not long enough. I do think that Mr. Fuller is on the right path. I don't mean to dismiss all the positive things that he's done, but this case is at the top of the list of the most heartless, dastardly murders that I've seen in all my years here. And so it's unconscionable to me how even a young person could plot to do this. This was not a youthful impulse. This was something that he and his co-defendant planned to do, and that he bragged to one of the eyewitnesses about, look, I'm going to go get me one. And so there were at least 8 shots fired, we know. The victim was hit twice. This was an adult crime. And just because his sentence has been amended to allow for parole consideration doesn't mean that he's entitled to it, and that he shouldn't have to work really hard and have a long proven record of his rehabilitation. So, Mr. Graham left behind a family. They're not on today, but he had people who loved him. He was known in the neighborhood. This traumatized a lot of people, eyewitnesses, neighbors who were just out in their yard raking leaves and became witnesses to a murder. A 2-year-old that had to be grabbed and rushed inside for cover whenever these shots rang out. The lady who was driving down the street and ended up taking Mr. Graham to the emergency room. So these are the kinds of crimes that are far-reaching in our community. And we just think that at this point, Mr. Graham's life was worth more than 30 years. And, we want to see more continued progress by Mr. Fuller. At this point, we think that parole would be premature. And, as I said, Mr. Graham deserved better than to leave this world at the age of 53 at the hands of 2 young men that were looking to earn a quick buck at the expense of another human's life. And so we heartily believe that now is not the time for Mr. Fuller. We feel at this point that parole would deprecate the seriousness of this crime and cause an undue risk to our community. So I do agree with something that Ms. Renata said in the last hearing, that he is on a path forward, and we respectfully request that he be kept on that path forward from Angola. Thank you for giving me time to share my comments.
Thank you. We always appreciate hearing from the DA's perspective. Thank you. All right, Mr. Fuller, I have some questions for you. Your case was, as I said, assigned to me, so I'll take the lead on the interview. When did you first start using drugs? How old were you?
I was around maybe 11, 12 years old when I first got introduced to it.
What were you introduced to first?
Marijuana.
Any alcohol?
Yes, ma'am.
Same age?
Yes, ma'am.
And so, why did you have a gun that day? Did you always carry a gun?
No, ma'am. No, ma'am. But that day is just, I guess coming up from where I'm from is just to have protection.
And that day was different for some reason. Well, because
Yes,
you said you didn't usually carry a gun,
no, ma'am.
but that day you just decided to do it.
Yes, ma'am.
Have you given that any thought?
Yes, ma'am.
Well, what you
A
think
lot.
about?
I think that I was so stupid as a young man. I think I made a lot of wrong decisions coming up in life as a young man. Decisions that today I see that they wasn't the right decisions.
Okay, what, so, you say you got your GED, right, since you've been
Yes,
there?
ma'am. Yes,
What
ma'am.
level, what grade did you finish in school? You said that particular day you skipped school. What grade were you in?
9th grade.
Ninth grade. Hmm. All right. Had you repeated any grades?
Yes, ma'am.
Well, tell me about that. Which ones?
I think that's the grade I failed in 9th grade.
Ninth grade, okay. So, when you had a hearing in 2020, I believe, as was mentioned, and what were the reasons you were told you were denied at that time?
I don't remember all the reasons, but I know at that time I was still in denial. I didn't take full responsibility for my actions. I didn't take full responsibility for using drugs. I was on drugs and I was in denial. I was ashamed and I just felt, I don't know. I just felt,
So you're saying you were on drugs as recently as 2020? Is that what you said?
I didn't use drugs since I've been here. Yes, ma'am.
Okay. When's the last time you did that?
Oh, I haven't did it now. It was before 2020, but I haven't done no drugs in years now.
Well, how many years? Most people know.
Since like maybe 2017, 18, somewhere up in there.
About the time you thought you might be eligible for parole. Is that what changed you? The hope?
I felt like I had hope again because I honestly thought that I was gonna die here. It's like nothing good has ever happened to me since I've been in the system, and I thought I was gonna die here. It's like I had no hope that this was my home.
Well, okay, so let's move on. I think that you were told at that hearing, I wasn't on that panel, but I looked at the record and I think you were told that you needed some substance abuse treatment, and the record
Yes,
shows
ma'am.
that you did you completed the STAR program. What'd you get out of that?
Oh, that was a life-changing event. Because through the STAR program, it taught me about recovery. It taught me about the core beliefs I had then as a kid and coming up now as a man. With the STAR program, a lot of men that have known me over the years here at Angola, they know my life then, even when I was smoking marijuana here. And they see the change in me now to where when they see me today, I get letters now asking me, what you did with your life? Man, how you change your life around like this? Look, man, I need some help. Man, help, whatever you doing, man, help me do this. And that makes me feel so good to be able to help another person because I know where you at, because I done been there. So look, come on, talk to me. And I will talk to them and I will introduce them to my facilitator. And we would do a survey on them. She would do a background check. And everybody, usually we wouldn't have number 8 people in the class. Right now we at 20. We don't go up under 20 because you have so many people from even the outer camps sending me word, telling me, man, I hear about what you're doing with your life. Man, I like what you're doing with your life. Man, how can I be a part of that? And I want to help because there's so many of my friends have OD'd up here and died off of drugs. And with the decisions I made as a youngster, now I can do something to help now. I can bring men this way. I can help get men off of drugs. That is a feeling I never thought I'd have, that I never thought I would love like this, to be able to help another man change his life.
Well, one of the questions I was going to ask you was about, tell me about your community service work. I think you just did that.
That was just a
And
part
also
of it.
your work with the vets.
Yes, ma'am.
That's
And
important.
a lot of times they might send a letter around to Camp F. We'll fill our name out to go over to Camp F and fellowship and talk to the brothers over there. We'll go over there and play them in basketball or flag football and sit down and eat with them and talk with them. I also do that. I also was getting with the brother Tyrone Glover. I became an active member of the round table with him. I asked him for help. Man, when I get out of here, can I help now? And if I'm eligible to get parole, will you help me when I get out there?
Okay, I have a couple of more comments, but I'm going to defer to my colleagues for any questions before I make those comments. Mr. Tillis, any questions? Ms. Prater?
Not really. I realized during the interview, the time you got most passionate was when Ms. Renata was talking to you about the STAR program and all the good that was, and you became a different person describing that. And
Because I love it.
Yes, sir, I can tell. And you've done some good work there. I want to congratulate you on that.
Thank you. I done helped so many men. I never thought I can do that. But the way I used to go to Ron Hicks and ask for help and he would help me, now I'm in his shoes to where you got a lot of men coming to me. Now I can help you. I can talk to you because I done been where you at. And now I can help you get to this point now. So I always tell them, man, come on, man, talk to me. I always was good at talking to people. Always.
I can tell.
Yeah.
All right.
Never,
Let us
I
talk.
never.
Hold on.
All right.
Didn't mean to start all that.
So, Mr. Fuller, I'm about ready to vote, but I wanted to make you aware of a couple of things. In
Yes,
the
ma'am.
record, we do have a letter from Mr. Willie Graham's daughter. This is what she has said. Her name is Tatiana Graham. Ms. Graham is unopposed to early release. She said, I believe he has served enough time on this crime. I love and miss my dad, but he has been gone for 30 years, and this guy was a kid when he shot him. I hope that he has learned his lesson and become a better person and will make something good out of his life if he gets out. How do you feel about that? All right, I understand. And so there's one other letter we have, and I feel compelled that I have to at least state it for the record. And this is from the state representative from District 4, that's Joy Walters. And she's written a very nice letter in support, saying that she believes, and this is just paraphrasing in part, she believes in a justice system that not only holds individuals accountable, but also recognizes growth, rehabilitation, and the capacity for change. And I think we see that in you. So I'm ready to vote. Mr. Fuller, my vote today will be to grant your parole based on your work, the comments by the warden, the support that you have, and particularly that of the Parole Project. I think it's very important that if you are successful today, you don't go back to Caddo Parish. I know your sister or somebody said they wanted to take you to be baptized there. That's something that can be happening in the Baton Rouge area. And then when you finish with their programming, because they'll have some programming for you, I would require community service work, at least 8 hours a quarter, and that is to speak to at-risk youth.
Yes, ma'am. I would love to do that.
All right, I'm just one vote. Mr. Tillis.
I concur with Ms. Renata.
Mr. Prater.
Okay, this is a very difficult job, but somebody that with your behavior and your all the positives. You make it less difficult for us to make decisions. Because of the age, your age at the time of the crime, because of the support from your family, the parole project's willingness to be involved, your behavior while you've been incarcerated, the victim letter, and the passion you've shown during your interview, my vote also is to grant this.
Your parole's been granted. Mr. Fuller, good luck.
Approved? Yeah, approved, and I'm all right with it. I am all right with it. So this went into half of our overtime hour. I didn't think it would run that long, but I think it was worth it. Let's face it. I put in the chat. I put a poll in. Is he believable? 43% of you said no, but 43% of you weren't sure. 14% of you were a yes. Dude was 17. He's been in there 30 years. And the victim's daughter said, let him go. So these things are never easy. And, we talk about the parole board so much here because they do things that we don't always understand. Sometimes we do, sometimes we don't. Sometimes they make all sorts of sense. Sometimes they make no sense at all. But we've always acknowledged that their job is incredibly difficult. Because even if they're really certain of a guy, they're taking a risk, aren't they, by letting the person out? But I think this was right in this case, again, because by all accounts, he's doing the right things. He's doing what you're supposed to try to do when you're in prison, and that's not become institutionalized as Judge Boyd always warns people, but rather work on yourself. And it appears that's what he has done. And again, the victim's daughter's like, dude was 17. He served 30 years. Let him go. So here's hoping that works out. Here's hoping that he leads a good life with the time he has left, fits in well to the community, becomes a benefit to the community. I kind of think he might, but we shall see, won't we? Granny says the victim's daughter sealed it for me. If she's willing, so am I. Yeah, that's kind of where I'm at. Because it probably should come down to them, at least in part. I think, the board, it's their choice, but I think the family's wishes after the fact here should carry some weight. And if the family is acknowledging that he's been punished enough, then, unless he was horrible in front of the parole board, which he was not, then I think it's the right choice. Her opinion would not have mattered if he was a complete mess in front of that board. But he had himself together. I think he showed the right amount of contrition, and I believe it was genuine. He's been working on improving himself, so I think it was good. Anywho, again, I wasn't planning on having a hearing that long here in the fourth hour, but worth it because it was all right. Couple things to comment on, and then there's a news story or two if we have time that are of interest. If you want to join me, if you're a channel member, you can do that. There's a link in the Discord, so you need to be signed up for the Discord to get it. The link changes every day, but if you want to join me on stage, you can, and I'd welcome you to do so. Look, participate. That's the reason that I added a fourth hour was for you guys to be able to interact with me more. So the sidebar panel will tell you I don't bite, so feel free to join. And if you're worried about getting on camera, you can leave your camera turned off and just join by voice. You don't have to have your camera on. But anywho, right out of the gate this morning, drunk lady in McNally's court. So the staff informs judge that she smelled of alcohol. So he sends her for a PBT, and she comes back and she blew a 166. So twice the legal limit. I get if you're nervous before going to court. I can totally understand that, because these things, any legal issue can be nerve-wracking for sure. But I think it takes a special kind of dumb to be drinking right before court. Because didn't she say she was drinking like right up to 4 a.m. if I recall correctly? And she was in there at like 9:30. So if she was a 166, allegedly having stopped drinking about 5 hours prior, then she was hammered, because she would have been on the way down. So at some point, she was probably approaching pass out drunk, which means she'd been drinking all night. But then she goes on about how her driver was like the 11th cousin twice removed from President Trump. So somebody put in the chat, it might have been Granny, that, clearly she has a mental issue. Maybe. There might certainly be a mental thing there going on, which causes the behavior of the drinking and the alleged crime and the what have you. But she could also be just one of those people who goes crazy when she's been drinking and starts making things up and seeing things and talking nonsense and all of that. Either way, not good. And I know some of you were surprised that McNally let her go. McNally's confusing to me, because he comes across, we call him Judge Dad for a reason. He comes across harsh so often. But he also seems to have a soft spot and a willingness to give people another chance. The only thing he could have really held her for at that point was contempt, which is kind of a pain in the neck for them. So it's probably in his mind a path of least resistance to just let her go, reset the thing, and hope that she learned the lesson from the embarrassment and gets it right next time. I don't know. But I'm definitely curious as to where it goes. Ashley, I don't know if you're still out there in the chat, and if you caught when she's coming back. I forgot, and I didn't write it down, so I'll watch the replay and see. But I definitely want to keep an eye on her and see what she's like when she comes back. Because if she's drunk again, yeah, I think it's going to be different at that point. I don't think she's walking away. That will most certainly be at least being held till the afternoon session in contempt to further scare the crap out of her. But we shall see. And then we had... Okay, well, thank you, Ashley. If you could do that, that'd be great. I mean, it's just worth following up on. So please thank Ashley, chat, because Ashley is like the official executive assistant of TCF. She keeps track of everything, and her value here to all of us is incredible. So do thank her, please. All right. And then there was the Judge Stevens guy. So just to be clear, because I wasn't clear on it initially, because I was listening to a couple of other courts when this started, but it got cleared up by the judge later on. So originally, this guy in 1989 was convicted of burglary of a building. And then in 2005, bad behavior with a child. And then he's got a new charge of burglary, there we go, of a habitation. So he's in front of judge for this new charge. He's got 2 other felonies, which we find out later that he, according to him, he didn't get his quote-unquote day in court. So he's all upset with the fact that he's got 2 felonies on his record and doesn't feel like he's been treated justly, and how he's, if I understood it correctly, he's working on getting those fixed, which is like really impossible for the 89 case and highly unlikely for the 05. That stuff's kind of done and dusted at this point. But then we find out that he's going to pick up another felony charge because he's trying to buy a witness. So there's this lady, and I'm a little unclear as to whether or not she is the victim or just somebody that he knows in the area or something. And I don't mean to sound dumb on it, but there was a lot of moving parts in that. So if you're going to go back and watch any portion of today's show, that's probably it. And I guarantee you this is going to be a standalone video tomorrow anyways, because it's that intriguing and complicated. So it will be spun off into its own thing. But he's in a situation where he's trying to buy her favoritism for $100. So he's an idiot and a cheapskate, because $100 doesn't even get you a trip to McDonald's for a family of 4 these days. So I don't know what he's thinking with that. But what got me with that, and you can tell me if you think different, but the most standout thing there beyond the lunacy was the fact that they put him up on the stand. Ex-girlfriend. Thank you, Barbara. I knew there was a connection there, but what I wasn't sure on is if she was also the victim. But again, I'm going to rewatch it myself because there was a lot of moving parts to it. But what got me was that his attorney put him up on the stand to start talking, and he didn't do himself any favors there, because judge was just getting ticked off by him. He was argumentative in a lot of ways. He's talking about how these other 2 felonies, well, I never had my day in court for those, so he doesn't take responsibility for his bad behavior and bad actions. And this is not a young guy. That's what gets me, especially the older I get. When I see people that are my age or older acting a fool, drives me up a wall. At my age, you should definitely know better. If you're older than me, you definitely should know better. I've been on record. I can get behind the one-off bad choice, because we've all made them. Just don't make that choice again. But this guy, he's got other plans, and the $100 to buy a witness is crazy to me. So he gets his bond doubled from $30,000 to $60,000. And the judge has asked that it be referred to the grand jury. So he's going to have yet another. And if I recall correctly, because of the previous 2 felonies, this new one was going to be a 25 to life potential. And now he's going to have another felony on top of that, which is going to be tried as well, unless they plea it out somehow. So it's insane. That was one of the more crazy and interesting things we've seen in Stevens Court. We normally don't see people on the stand unless he's doing a full-blown trial. So that was fun to watch. But this has been a good day. Great Granny, don't forget about the ex-girlfriend witness that he tried to get her to write a letter saying nothing was in his truck. Yeah. And then you say, me too, Dan, we should have learned by the time we get to our age that crime doesn't pay. You would hope that we would learn. Again, I don't get too harsh on people for making mistakes along the way and making bad choices along the way, because we'll all do it. I mean, there's some things that are definitely more egregious than others, and we know what those things are, and some of them you can definitely argue are not forgivable, but most things are. Most things, even the burglary of the building, stupid choice, pay your price, fix yourself, and you could move on from that. But to keep doing dumb things over and over, especially when you get up there in years, is just insane to me. Alrighty, let's pull up some media real quick, go through a couple of things, and then we'll call it a day. So yesterday we were talking about the Savannah Guthrie's mom thing, and if you're not familiar, if you weren't with us yesterday, this happened over the weekend. Savannah Guthrie is the co-host of the Today Show on NBC. Her mother lives down in the Tucson area here in Arizona, where the TCF bunker is located, and mother just went missing over the weekend. Well, some stuff has come out, or been reported rather, that first off, TMZ apparently received a ransom letter and they have turned it over to the FBI to try to authenticate it and see what's really going on with it. But then Ashley Banfield, who I believe is on News Nation, actually reported last night that the son-in-law of the mom, not the one that's married to Savannah, but married to Savannah's sister, is a suspect, and supposedly his car was towed last night. Now, this morning, however, the sheriff's office in Pima County is pushing back. They tweeted this out or X'd it out or whatever you do over there now, just a couple of hours ago. At this point, investigators have not identified a suspect or person of interest in this case. Detectives continue to speak with anyone who may have had contacts with Mrs. Guthrie. Detectives are working closely with the Guthrie family. We appreciate the public's concern. The sharing of unverified accusations or false information is irresponsible and does not assist the investigation. No suspect or person of interest has been identified at this time. So this is kind of becoming a little bit of a poo-poo show, in my mind anyways. Because you got the media tracking down leads and trying to figure stuff out, and the sheriff's department's like, no, we don't know what's going on, which I get the idea that they don't want to like release stuff that might hamper the investigation, but there's this habit in a lot of police agencies now to just do flat out denials for everything. And then later on, the things that they were denying proved to be true, and it kind of ends up being egg on their face. So regardless of that, I'm going to continue to keep an eye on this story, because it's a national story. It's happening in our backyard here in Arizona. And it's a little bit disturbing that an 84-year-old woman just kind of minding her business is abducted from her home. I mentioned this yesterday, I don't see a motivation to that unless it is money related. Could be wrong. Who knows? If it was, I will say though, if it is like the son-in-law, if he is involved, then there might have been something other than a money issue. But in the same respect, yeah, he's certainly not going to get away with it, is he? So, I don't know. Great Granny, they won't tell if they did or didn't have a suspect this early in the investigation unless they had a suspect in hand, in my opinion. I would tend to agree with you, but there's a little too much silence that's going on with all of this. The only thing they're saying is it's a criminal investigation, but normally we'd have a little more info out of them that would at least involve the public a little bit more, which makes me wonder exactly what's going on. It's just bizarre, but time will tell. I'm going to keep an eye on it. So one more story that we've got time for, and I wanted to bring this one yesterday, but we got caught up talking about the other crazy. But this is interesting because it involves a judge in Detroit. Now, this is not a judge that we follow here on TCF. I'm not sure that she even streamed her court. But Detroit judge, 3 others charged in alleged scheme to steal thousands from vulnerable and incapacitated people. A Detroit judge and 3 others charged by federal prosecutors for their role in a years-long scheme to embezzle money from incapacitated and vulnerable individuals. U.S. Attorney's Office for the Eastern District of Michigan said Andrea Bradley Baskin, 46, a district judge on the Michigan's 36th District Court, is alleged to have used $70,000 in a ward's funds to purchase an ownership stake in a local bar and money embezzled from the estate of a ward to pay a 2-year lease on a new Ford Expedition for herself. Quote, we respect the authority that covers a black robe. This state judge and her cronies allegedly abused that high honor for personal gain by preying on the needy protected by the court, U.S. Attorney Jerome Gorgon said in a statement. This would be a grievous abuse of public trust. Regardless of a person's position in society, no one is above the law, added Jennifer Runyon, special agent in charge of the FBI Detroit field office. These 4 defendants allegedly conspired to steal from some of the most vulnerable citizens, looting bank accounts, exploiting legal authority, and profiting off those who relied on them for care and protection. The attorney's office said Nancy Williams, 59, Avery Bradley, 72, and Dwight Rashad, 69, and Bradley were charged with conspiracy to commit wire fraud, which is the one that the feds always run to because it is the one that sticks. Wire fraud and mail fraud. The actual crime that you did doesn't matter. This one sticks. Quote, the indictment also charges Bradley with 1 count of wire fraud, Bradley Baskin, and Rashad with several counts of money laundering, and Bradley Baskin with a single count of making a false statement to federal law enforcement agent. Lawyers represented Bradley Baskin did not immediately respond Saturday to a request for comment from Fox. The attorney's office, citing the indictment, said probate courts regularly appoint guardians and conservators to manage the personal and financial affairs of adults, known as wards, who have been found by the court to lack the capacity to do so for themselves. The indictment alleges that Nancy Williams owned Guardian and Associates, an agency that was appointed as a fiduciary by the Wayne County Probate Court for incapacitated wards in over 1,000 cases. Avery Bradley is an attorney who, along with his daughter and fellow attorney Andrea Bradley Baskin, operated a law firm that often represented Guardian and Associates in Wayne County Probate Court and otherwise practiced regularly in that court. Dwight Rashad operates a series of group homes and residential facilities for elderly individuals, including wards, who needed support and care. The indictment alleges that the 4 defendants conspired to systematically embezzle funds from the wards and to obtain and retain money for themselves that rightly belonged to the wards and the wards' estates. Prosecutors described how in one case, Bradley, Williams, and Rashad allegedly took around $203,000 in funds from a ward's legal settlement, and with none of the money being used to benefit the ward. Williams is alleged to have paid Rashad rent for wards who did not live in one of Rashad's homes, they said. Case is being investigated by the FBI and the IRS criminal investigations. There is nothing worse. Well, there's a lot of things worse. For what we watch here on TCF, you could make an argument that there's nothing worse than a judge behaving badly. But somehow this doesn't surprise me. One of the things I see in the comments a lot here is how people can't believe that a judge does this or that. And specifically when they make those comments, they're asking or seeking for the judge to supersede his or her authority, to be heavy-handed with something, to come down harder on somebody, even when it's not within their authority to do so. They want to grant all of this power and this control over to the one person in the black robe. And I would say, if nothing else, cases like this continue to prove that the people in the black robe have the capacity to be just as flawed, if not more so, than the rest of us. So taking all of that power, consolidating it in one person or in one position is just like the worst idea in the history of ever. So for me, this case is yet another reminder that you can't do that. There's bad people everywhere. Of course, this is allegations at this point. We'll see what proves out as the case moves on. And this is another thing I'll keep an eye on. But at the end of the day, you can't truly trust anybody, it would seem. And you always have to be on the lookout and never give too much power to one person or one group of people, because power corrupts, and more often than not, it would seem, something will happen, something will go wrong. And in this case, hundreds of thousands of dollars gone missing from the people who needed it the most. So just my thoughts on that. All right, friends, we're pretty much ready to call it a day. I hope you had fun. I thought this was a good day in court today. A lot of good things that we saw. Some redemption, some crazy, some drunkenness, all the things we love here at TCF, I suppose. Do join us tonight over at In the Blind, 7 p.m. Eastern, 4 Pacific. There is a link in the pinned chat. If you like what we do here, please give us a try over at In the Blind. It's not lost stuff, but the shtick over there is Michael and I are given 2 topics in real time, and we have to talk about them. We have no idea what they are ahead of time. And they've been some pretty interesting topics. Like one of them, the last show that we did was microdosing versus like pharma, and what's the ethics and the legality of all of that. And it's interesting. But my favorite part is at the end where we do the true false lightning round, because we're presented with some crazy stuff and we got to figure out if it's real or not real. So do check us out there. Again, the link's in the pin chat. But otherwise, I will see you tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. If you're a channel member, join me half an hour early. But in the meantime, go have yourselves a great day, and we'll see you soon. Take care. God bless.